Welcome to the regularly scheduled meeting of the Sunshine Ordinance Task Force for August 23rd, 2011. Administrator, will you please call the roll?
Yes, Madam Chair. Member Snyder?
Present.
Snyder present. Member Nee?
Here.
Nee present. Member Washburn?
Here.
Washburn present. Member Costa?
Here.
Costa present. Member Johnson?
Here.
Johnson present. Member West?
Present.
West present. Madam Chair, we have a quorum.
Okay. We have a number of members who are sorry, my mic got turned off, who are absent today. So we need to vote on whether it's an excused absence. Member Nee?
Madam Chair, have the absentees given reasons for their absence?
Yes. We have Member Wolf is on vacation. Members Cawthon and Hanley are both ill. And Member Manet was delayed due to work. She has a meeting and a deadline. Mr. Rustum, did Mr. Kneber provide a reason why he could not attend?
Yes, Madam Chair. He said he's on his way back from Peru.
Oh.
And will arrive late this evening.
Okay, so he was on vacation. Is there a motion to excuse the members?
So move.
Second.
Mr. Rustum, will you please call the roll?
Yes, Madam Chair. On the motion, Member Snyder?
Yes.
Snyder, aye. Member Nee?
Aye.
Nee, aye. Member Washburn?
Aye.
Washburn, aye. Member Costa?
Aye.
Costa, aye. Member West?
Aye.
West, aye. Member Johnson?
Aye.
Johnson, aye. Madam Chair, there are 6 ayes. The motion passes.
The members are excused. Are there any agenda changes? There is one I know of that is items 16 and 17 are continued at the request of both parties. Is that correct, Mr. Rustum?
Yes, Madam Chair, that is correct.
And I believe we have one additional request for a continuance.
Yes, that is correct.
The respondents on complaint 11046, Charles Pitts against the Shelter Monitoring Committee, have requested a continuance. They've requested a continuance since July, I believe it's the 25th. There's a letter in front of you dated August 23rd. Is the complainant present? I'm sorry, were you from the shelter?
From the Shelter Monitoring Committee. As I indicated to Mr. Rustrom, I actually have to leave right at 4:30 due to a prior commitment, which is the reason we can't be here. So I'm not sure that I'll have time in the next 6 minutes to address your questions.
Okay.
I'll let the complainant go first.
Thank you. Mr. Pitts, do you disagree with the continuance?
I disagree with it because of these documents that I'm going to submit. I submitted them in duplicate. See, the problem is that they're implying that she's the only person that's qualified to come here and address this complaint. So in the complaint here, like if you talk about if you ask her about the qualifications of the LJ Cirillo, I think she has a high level of college in bioengineering or something, and she's the chair. The other thing too is this person, Mr. Luton, from the documents that I'm submitting, it looks like he has a law degree, some type of law degree. And the other thing too is, I believe this Elizabeth Anchor, I believe she has some legal schooling as well. I didn't bring anything to prove that.
Are you? Are those people from the committee
Yep.
that you're reading? Okay. And is there a reason why you were the only person available? Yeah.
The reason that I'm the only one available is there were more people available on the 26th when we were originally supposed to be here, but because of scheduling and people's work schedules, because these are volunteers, no one was able to go. I always come to the Sunshine Task Force or any other meeting to help the committee answer questions about documents or procedures that they may not be familiar with. So the reason I'm here is because there was no one on the committee who was able to come today on the 23rd. We tried to find someone the day we got the notice it had been changed.
Okay, thank you. Mr. Rustum, is the reason why it was moved from July 25th because the complainant added,
Yes, Madam Chair, the complainant changed the complaint.
and
So
he
it goes into
added
the
people, so you had to give notice to the new people?
That is
before-
correct, yes.
Oh, okay. Any discussion from the task force? Member Nee?
Mr. Pitts,
Yes.
if this matter is continued, what inconvenience does that cause you?
Cause me?
Yes.
I believe it doesn't cause me any inconvenience, but I just feel as though it's getting kicked down the line, just continuously getting kicked down the line. And to me, part of it is just that what they did was so egregious that it was just highly egregious what they did. But I want to submit these documents into the record as well.
Do you believe someone could be here in September?
As soon as I have a date, I can make sure that I'm here. I can't speak to any of the other committee members until I'm given that date, but I will be here.
September 27th.
I will be here.
So personally, I'm somewhat reluctant to not continue it. I hate to keep pushing it back, but since part of the reason why it was pushed back in the first place is that somebody was was added to the complaint, it seems, reasonable because the nature of the complaint is going to require us asking questions of somebody who knows about the meeting. Member Nee?
Well, ordinarily, I would lean against continuance. However, particularly since Mr. Pitts has indicated that he would not really be inconvenienced, and I think we could have a much more fair hearing into this if both sides were present. If the respondent has to leave at 4:30, there may be questions that we want to ask her that she would not be available to answer, and that would not be fair to either side. So, given that, I move to continue this items number 10 and 11.
I second that.
Public comment on it? It's not on the agenda. Is there public comment on the motion to continue? Seeing none, public comment is closed. Mr. Rustin, will you please call the roll?
On the motion, Member Snyder?
Yes.
Snyder, aye. Member Nee?
Aye.
Nee, aye. Member Washburn?
Aye.
Washburn, aye. Member Costa?
Aye.
Costa, aye. Member West?
Aye.
West, aye. Member Johnson?
Aye.
Johnson, aye. Madam Chair, we have 6 ayes. The motion passes.
The items 10 and 11, the complaint filed by Mr. Pitts against the shelter monitoring committee is continued until our September hearing. I apologize to you, Mr. Pitts. We just really believe that we would have a more fair hearing with people present. And if it hadn't been, a series of circumstances with you adding someone, and then we're always reluctant to continue it.
I mean, it's workable. I think the thing is I'm concerned that you'll be able to show and play the video that I produced.
Mr. Rustum, do you have the video?
The video is in a format that is not supported by the city, Madam Chair.
Can you get to it?
What's the format?
It's in the MP4 format.
Oh, I believe you. Is it the only format that it's in? Do they have video online that we can look at?
No. I mean, I asked if they could download a video player, or maybe if he has it, we could probably try it on the VCR or whatever it is.
Well, Why don't we have Mr. Rustum email the video to me and Bruce Wolf, maybe Member Costa, so we can try to figure it out. And since there's a number of days, we can work really hard to get the video available, at least here, to play on a laptop or something. Is that, we can have that available?
Yes, Madam Chair.
Okay.
Okay, I appreciate it.
Thank you, Mr. Pitts. Is there any further changes?
Hi, I'm Lee Munson.
Microphone, please.
Thank you. I'm Lee Munson. I'm the Vice President of the Library Commission, and I'm here to speak on items 12, 13, 14, and 15, along with Sue Blackman, who's the Secretary of the Commission. We're sort of, if it takes half an hour, though, for each item, that's going to be six hours before you could take us. And I'm diabetic, and I have to eat. It's a very simple matter. And Sue has another engagement. So if it would run past 6 or 6:30, I'd have to get some food in me. Could you either continue this or schedule it before 6?
But unfortunately, the option of scheduling it ahead of the other cases is not really one we can take because they've been continued from the last hearing. So that's really difficult for us to push those back. A couple of these people waited until very late.
I understand. Sue Blackman has come to a number of meetings, and she's waited through your entire meeting till 10 o'clock, and then she's told, well, sorry, you have to come to the next one. And she had a vacation, long scheduled transportation she had paid for, and there was no flexibility at that point. They expected her to cancel, lose her deposit, lose her reservation.
We don't generally expect people to cancel their vacation plans, but we do expect that the departments would have more than one person who could speak to a complaint. Although in this instance, some of these people have had their hearings pushed back from last, so it's going to be difficult. And there's a possibility we could continue it. Is the complainant present?
I think I see Mr. Hartz here.
Mr. Hartz, would you have an objection to continuing?
Members of the task force, Ray Hartz, Director, San Francisco Open Government, and yes, I would object because Ms. Blackman raised the question of her not being able to stay past 6 o'clock by email. And I directed it back to the task force and said, if she can't come, then they can send somebody else. I don't know why Mr. Munson is here. This is not a complaint against the Library Commission. Is it against Luis Herrera, the city librarian in the San Francisco Public Library. And both Ms. Blackman and Mr. Munson are here supposedly to represent the Library Commission against the complaint is not even against. And the bottom line is they have other people they can send. Mr. Herrera is a public official. He knows his duty under sunshine, and he had plenty of notice that I would object to this and made no effort whatsoever to get someone else to come to do this. Very frankly, Mr. Munson can present items on behalf of the Library Commission, but Ms. Blackman is a city employee. Her direct supervisor in city government is Mr. Herrera, and that was why the complaint was placed against him, and the Library Commission is a secondary party, if a party at all.
Thank you. Member Nee?
Unfortunately, given the length of our agenda and the number of complaints we have, everybody here is going to be inconvenienced somewhat. If we keep juggling the agenda, I think it defeats our purpose. We have the agenda is set in a certain order because that's the way our procedure sets it up, and we bend over backwards to be accommodative, but at some point we do have to draw the line. And in this case, I would be opposed to juggling it, and I am opposed to continuing the matters.
No, I'm sorry. Is there any other discussion? Sorry. What? Are you, which one of you is representing the?
Well, he's representing the Library Commission. I'm the Library Commission Secretary.
Okay, I feel that you've already had an opportunity to
I just
speak.
want to stay.
I feel that you've already had an opportunity to speak. I'm sorry. We have lots of people who are waiting, and it's very unfortunate, but we have to move ahead, and these people have been waiting since last week.
But-
Is there a motion from the task force?
No motion is necessary
No
if we do
motion.
not move to continue.
Seeing no motion, we are not going to continue this matter.
Okay. Just for the record, she did not speak today on this subject. I'm sure you would like to know that.
I feel that the respondents had their opportunity to make their case.
Oh, all right. I spoke. I made our case, yes.
And Mr. Hart's made his case, and unfortunately, we just cannot continue. We can't move it ahead, and we can't continue this.
Okay, then I will speak later. I will get an early supper, but don't accelerate it. I'll go out and get an early supper, and I will come back.
I appreciate your making the effort. Thank you. Is there any further changes?
Commissioner Johnson, I'm Mike Helms. I'm a manager from Labor Relations at the San Francisco SFMTA, and first time at your meeting, and I don't know if I'm out of order. If I am, I'm sure you'll tell me. But I've been sent here to ask for a continuance on item number 6. We believe that there is some more information that we do need to provide, and we would like the time to provide the adequate information. So if, I've been asked to come here and ask for a continuance, and hopefully we can provide that in committee. If I'm out of order, I'm sure you will tell me.
Is Mr. Maxwell present?
I don't know.
Mr. Rustum, did you hear from Dorian Maxwell?
Madam Chair, no, I did not.
Member Washburn?
I'm reluctant to continue this because Mr. Maxwell could come shortly, and I would still like to give him an opportunity to have his matter heard.
Since we have no indication that Mr. Maxwell, since we have no indication that Mr. Maxwell is not coming, if we could move forward with our agenda and wait a minute to see if he shows up, we could revisit it at the end of one of the items.
Thank you for your patience, and I'll wait as long as it takes.
Thank you.
Thank you.
Are there any further agenda changes? Seeing none, Mr. Rustin, will you please read the first item?
Yes, Madam Chair. The first item is determination of jurisdiction on complaint filed by Pastor Gavin against Supervisor Chu and Supervisor Ma for allegedly violating Sunshine Ordinance requirements for public notices and agendas.
Move to find jurisdiction.
Second.
Moved and seconded for jurisdiction. Mr. Rustin, will you please call the roll?
Excuse me.
Sorry.
Point of order. We do
Public comment.
Public comment.
Sorry about that. Is there public comment on jurisdiction? Seeing none, public comment is closed. Mr. Rustin, will you please call the roll?
On jurisdiction, Member Snyder?
Yes.
Snyder, aye. Member Nee?
Aye.
Nee, aye. Member Washburn?
Aye.
Washburn, aye. Member Costa?
Aye.
Costa, aye. Member West?
Aye.
West, aye. Member Johnson?
Aye.
Johnson, aye. Madam Chair, we have 6 ayes. The motion passes.
Mr. Rustin, will you please call item number 2?
Item number 2 is hearing on complaint filed by Pastor Gavin against Supervisor Chu and Supervisor Ma for allegedly violating Sunshine Ordinance requirements for public notices and agendas.
First, the complainant will have 5 minutes. Are you Pastor Gavin?
Yes, I am.
Welcome. You have 5 minutes.
Under the Sunshine Ordinance, it is the government's duty to elected officials, commissions, boards, councils, and other agencies in the city and county of San Francisco to serve the public, reaching its decision in full view of the public. On May 24, 2011, it was a dark day for the city and county of San Francisco when procedures at the Land Use Committee and subsequently at the Board of Supervisors meeting were violated under the Sunshine Ordinance. A week before May 24th, 2011, the San Francisco Civil Grand Jury released their investigative report regarding the Parkman-Said project. They called the report Government by Developer. In the first paragraph of the conclusion of their investigative report, it states, the Parkman-Said mixed-use program development agreement, for all its complexity, fails to mitigate the most significant risk it creates, the direct loss of statutory rights by the Parkman-Said citizen tenants. The San Francisco Civil Grand Jury consists of ordinary citizens such as yourselves who are concerned about our local government. The overall conclusion of the San Francisco Civil Grand Jury report is scathing. Due to this report that was made public, it precipitated what appears to be a clandestine 11th hour maneuver that caused the city and Parkman-Said developers to make last-minute changes as the deadline to amend the agenda for May 24th Land Use and Board of Supervisors meeting was fast approaching, thus giving impetus to the procedures that violate the Sunshine Ordinance, the reason why we are here today. On May 24th at the Land Use meeting, Supervisor Chu joined the supervisors who consist of the committee. He asked the committee to add 14 pages of revisions to the development agreement and to forward them to the Board of Supervisors later that afternoon. Supervisor Marr was the lone vote who voted no, stating there could be possible violations with the Sunshine Ordinance. He was outvoted by the rest of the supervisors at the meeting, and thus these 14 pages of revision I shall now refer to as the phantom 14 pages. It should be noted also that at the Board of Supervisors meeting, Supervisor David Campos in the video stated there could be a possible violation of the Sunshine Ordinance, and he himself had not had a time to read these papers nor comprehend them in part of the document as whole. Also at the Land Use Committee meeting and at the Supervisors meeting, the public, including some residents of Parkman-Said, were denied the opportunity to read the 14 pages of revisions, and they were only given a 2-page summary that relates to 14 pages that are a part of a document that is 200 pages overall. In the words of the City Attorney, Charles Sullivan, he stated that there was no need to give public comment because there had already been public comment. We disagree with that statement because the continuance was for the board to read the 4 EIR appeals, the Environmental Impact Report appeals, and to consult with the City Attorney's Office in regarding those appeals. That's why there was a continuance of nearly 2 months regarding this subject. This was such a contentious meeting regarding the phantom 14 pages that we did not even get to the discussion of the EIR, which 4 people paid $500 for each. So that's just how so many things just really seem to have gotten out of hand, from the 2-page summary to 14 pages that are a part of 200 pages. The additional phantom 14 pages substantially changes the document, which is another violation of the Sunshine Ordinance. 14 pages to anything substantially changes an entire document. Also,
Your 5 minutes are up if you could wrap it up.
Also, that is why we are here, because of the violation at which there was no opportunity for the public to address the revision of these 14 pages, and this decision impacts the homes of over 5,000 people, and you as well as citizens, because there are environmental issues involved with this project. Thank you very much.
Thank you. Are there members present to present facts and evidence in support of the complainant?
Yes.
You have 3 minutes.
Section 61, 7.1, Findings and Purpose. Section 67.1A, Government's duty is to serve the public, reaching its decision in full view of the public. Section B, elected officials, commissions, board, councils, and other agencies of the city and county exist to conduct the people's business. The people do not concede to these entities the right to decide what the people should know about the operation of local government. On May 24, 2011, under the Sunshine Ordinance, the rights of the residents of San Francisco were violated with the addition of the phantom 14 pages during an 11th hour maneuver of the Land Use Committee and subsequently at the Board of Supervisors meeting because no transparency was provided. The members of the public nor I were allowed to read the phantom 14 pages, and it was the last opportunity for us to provide meaningful public comment that involved a decision that pertains to our homes. My husband and I live in San Francisco, and Park Merced has been our home for over 30 years.
Ma'am, did you wish to state your name for the record? You don't have to, but
No.
okay. Is there anyone else to present facts and evidence in support of the complainant? Thank you. You have 3 minutes.
Good afternoon. My name is Laura Traveler, and I'm a member of the Park Merced Action Coalition, and we are here in total support of Pastor Gavin and the concerns that she is relating to us concerning the mythological 14 pages. I'm here to discuss Section 67.1. The right of the people to know what their government and those acting on behalf of their government are doing is fundamental to democracy, and with very few exceptions, that right supersedes any other policy interest government officials may use to prevent public access to information. Only in rare and unusual circumstances does the public benefit from allowing the business of government to be conducted in secret. And those circumstances should be carefully and narrowly defined to prevent public officials from abusing their authority. Public officials who attempt to conduct the public's business in secret should be held accountable for their actions. Only a strong open government and Sunshine Ordinance enforced by a strong Sunshine Ordinance task force can protect the public's interest in open government. On May 24, 2011, under the Sunshine Ordinance, the rights of the residents of San Francisco were violated with the addition of the phantom 14 pages during an 11th hour maneuver of the Land Use Committee and subsequently at the Board of Supervisors meeting because they provided no transparency. We were not allowed to read the phantom 14 pages, and it was the last opportunity for members of the public, my neighbors and I, to provide meaningful public comment that involved a decision that pertains to our homes. My family and I live in San Francisco, and Park Merced has been our home for over 25 years. Thank you very much.
Thank you. Is there anyone else to present facts and evidence in support of the complainant?
Hello?
Thank you. You have 3 minutes.
Yes. Section 67.7, Agenda Requirements, Regular Meetings.
A description is meaningful if it is sufficiently clear and specific to alert a person of average intelligence and education whose interests are affected by the item that he or she may have reason to attend the meeting or seek more information on the item. The description should be brief, concise, and written in plain, easily understood English. It shall refer to any explanatory documents that have been provided to the policy body in connection with the agenda item, such as correspondence or reports, and such documents shall be posted adjacent to the agenda, or such documents are of more than 1 page in length, made available for public inspection and copying at a location indicated on the agenda during normal office hours. Bamboozled. This kind of trickery is not only in violation of the Sunshine Ordinance, but it is insulting to all of us here in this room tonight. Only the writer of the revisions can understand a 2-page summary that correlates to 14 pages that are now part of a document over 200 pages long. On May 24th, 2011, San Franciscans and I were denied the last opportunity to provide meaningful public comment to a decision that impacts my home. I live in San Francisco, and Park Merced is my home. Thank you.
Thank you. Is there anyone else to present facts and evidence in support of the complainant?
Good afternoon, Commissioners. I'm here to support Pastor Gavin. I would like to address Section 67.15, Public Testimony A. Every agenda for regular meetings shall provide an opportunity for members of the public to directly address a policy body on items of interest to the public that are within policy body's subject matter jurisdiction, provided that no action shall be taken on any item not appearing on the agenda unless the action is otherwise authorized by Section 67.7E of the article that a threat to public safety. Section 67.7E refers to natural disasters or a threat to public safety. It provides the board with provisions to act in an emergency. However, in the case of a meeting of the Board of Supervisors, the agenda need not provide an opportunity for members of the public to address the board in any item that has already been considered by a committee composed exclusively of members of the board at a public meeting wherein all interested members of the public were afforded the opportunity to address the committee on the items before, during the committee's consideration of the item, unless the item has been substantially changed since the committee heard the item as determined by the board. I am an appellate who filed an appeal regarding the environmental impact report about the Park Merced project. We were hoodwinked by the phantom 14 pages that were not on the agenda, that substantially changed the agenda and thus denied the last opportunity to provide meaningful public comment on the decision that impacted our homes. I live in San Francisco, and my family has been in Park Merced for over 45 years. Thank you very much.
Thank you. Is there anyone else to present facts and evidence in support of the complainant?
Good afternoon. I'm speaking on Section 67.15, Public Testimony. C, a policy body may adopt reasonable regulations to ensure that the intent of subdivisions A and B are carried out, including but not limited to regulations limiting the total amount of time allocated for public testimony on particular issues and for each individual speaker. Each policy body shall adopt a rule providing that each person wishing to speak on an item before the body at a regular or special meeting shall be permitted to be heard once for up to 3 minutes. Time limit shall be applied uniformly to the members of the public wishing to testify. How much time is 0? 0 is the amount of time limits the public, and I were given to address the phantom 14 pages. This was a blatant violation of the Sunshine Ordinance under the public testimony section. The rights of the public, along with myself, were violated and denied the last opportunity to provide meaningful public comment on a decision that affects my home. I and my husband live in San Francisco, and Park Merced has been my home for over 20 years. Thank you.
Thank you. Is there anyone else to present facts and evidence in support of the complainant?
Section 67.24, public information must be disclosed. Not withholding a department's legal discretion to withhold certain information under the California Public Record Act. The following policies shall govern specific types of documents and information and shall provide enhanced rights of public access to information and records. Drafts and memoranda. College instructors are required by law to provide a syllabus that describes the requirements for their classes. I am a college student who graduated from City College with honors, and I am still contemplating what the phantom 2-page summary means. I do not think medical canvas could help anyone who did not have access to all the documents comprehend them either. How can these 2 pages explain the phantom 14 revisions that are a part of a document over 200 pages? The Sunshine Ordinance provides transparency and accountability of government at the local level to prevent local officials from abusing their powers. These types of shenanigans are unacceptable and in violation of the Sunshine Ordinance. I live in San Francisco, and Park Merced is my home. Thank you.
Thank you. Is there anyone else to present facts and evidence in support of the complainant?
Good evening, Commissioners. My name is Mitchell Omerberg. I'm an attorney with the Affordable Housing Alliance who has been assisting the residents at Park Merced for the last year or so. And I want to just briefly review the chronology of what occurred that morning to make it clear to you what kind of violation it was that occurred. But first, it's important to understand that it's a legislative act that we're complaining about, but it's slightly different than your typical legislative act. In this case, we had a development agreement, and so the Board of Supervisors actually considered a piece of legislation which was relatively short and approved a separate agreement which it referenced. This is only the second development agreement that the Board of Supervisors has approved, although there are common around the state. So that morning, the board's legislative committee charged with this subject matter had before it this legislation to approve a development agreement. We were aware that there were some 13 or 14 pages of amendments to the development agreement that had been drafted. We were told overnight, Charles Sullivan and the developer's attorney were up all night doing that. So here we are at 9 or 9:30 in the morning during the hearing on this topic, and I actually, sitting in the middle of the hearing, got out my cell phone and started calling Supervisor Chu's chief of staff saying, where's the text? And I was rewarded halfway through the hearing, as were some others, by being handed the text. I was not able to really digest it at that time or comment on it in any way or see if it was good or bad or, in fact, see if late-night drafting had resulted in language that accomplished what people thought it would. It's kind of arrogant to think that you can stay up all night and write something and you shouldn't take another look at it in the morning. Many people in the audience, however, didn't even receive a copy of it. So the committee then voted on this legislation. We asked for a continuance for the purpose of reviewing it. Supervisor Wiener pointed out that we were opposed to the project, which is true. We are opposed to the demolition of 1,538 homes. But nonetheless, in trying to represent people, we wanted to at least see if this language said what it purported to say and what the authors of themselves thought it might say. We didn't have that opportunity in any meaningful way during the hearing. Two of us met with Michael Yarney from the Mayor's Office of Economic Development and Deputy City Attorney Charles Sullivan during a kind of testy lunch while we kind of flipped through it and saw that various points were, but we never really had a chance to read the documents and see if they said what they said, or in fact what they said at all in any meaningful way. That afternoon, the Board of Supervisors approved the ordinance, which approved the development agreement, kind of making it a little bit like a, now we're starting getting in the area of a shell game where you're approving something that approves something else, but that other thing is changing and no one knows exactly what it is. There's also, when you do change a development agreement, a government code development agreement, if you change it in a way which arises above some threshold of significance, you are supposed to send it back to the Planning Commission, and that wasn't done. In any case, there was nothing here, to me, my mind, that meets reasonable notice, transparency, openness, sunshine, or any of the terms that would be applied to an open process. And although I had a little inkling of what was going on, the public at large was completely shut out.
Thank you.
Thank you.
Is there anyone else to present facts? And this is not general public comment, just by the way. Are you here to present facts and evidence
Yes.
for the plaintiff?
Steve Zeltzer, I'm with
3
United
minutes.
Public Workers for Action. I was at this hearing to speak on this proposal, and there were no copies for the audience of this agreement. How do they expect the public, the citizens, the residents of San Francisco to comment on something they don't have copies of? It's inexcusable. And frankly, it shows the contempt by the mayor of San Francisco, Mayor Ed Lee, and attorney David Hsu, who is also president of the Board of Supervisors, for the residents of San Francisco and the citizens. They want to vote on something when people don't have a chance to see it. This is unacceptable and contemptible. And we have to say, no, you're not going to get away with this. You're not going to shove something down the throats of the people of San Francisco without the residents, particularly those who are going to be thrown out of their homes, the right to respond to it. Why didn't they want the residents to know what was in this? You know why? Because they say that a state law can be overridden by a separate agreement that they have with the developer over rent control. That's what this was about. In order, we don't have to pay attention to the state law because we have a separate deal with the developer. This was a sham hearing to prevent the people of San Francisco from actually seeing what was involved in it. State law takes precedence over any agreement that the city of San Francisco has with the developer. So any agreement that the city makes with the developer can be overturned by somebody saying it violates state law. That's what they didn't want a discussion on. That's why they prevented us from getting a document of this at that hearing to address it. This is contemptible, and it shows really the corruption, the systemic corruption of our politicians who put their interest in the developer's money before the people of San Francisco and the residents of San Francisco who need homes. Thank you.
Thank you. Is there anyone else present to present facts and evidence in support of the complainant? You will not be able to speak again at public comment if you speak now. I'm just letting you know it's not general public comment on that case. Okay.
I'm not sure I understand the distinction. My name's Dacia Bowler, and I'm a member of the board of the Gray Panthers. And I just want to let you know that we are concerned about the well-being of the residents in Park Merced and had a meeting on the subject and are informed about it. And I'm here to speak on behalf of their complaint that with the problems with the Sunshine Ordinance, and hope that you will decide to protect their citizens' rights. Thank you.
Thank you. Is there anybody else present to present facts and evidence in support of the complainant? Seeing none, is the respondent present? Hi, you have 5 minutes.
Hi, good evening. Lynn Xiaochin, legislative aide for Supervisor Eric Marr. It's true that there were 14 pages of amendments introduced at the land use meeting. However, those amendments were introduced by President Chu. Supervisor Marr did not receive those amendments in advance of the meeting and was also surprised by them during the meeting. I understand that a number of the complainants and supporters are angry about what happened at Park Merced, but I would like the task force to consider that none of them have presented evidence as to why this complaint is being filed against Supervisor Eric Marr. He received the amendments at the same time. And so it is our position that, that this complaint should not be valid, and that, in fact, Supervisor Marr voted against these 14 pages of amendments in support of the Park Merced residents. Thank you.
Thank you. Is there anyone present to present facts and evidence in support of the respondent? Seeing none, the matter is with the task force. Member Nee and then Member Costa.
Ms. Xiaoqin, I hope I pronounced your name correctly, ma'am.
Ms. Chin.
Ms. Chin. Okay, thank you. What is the makeup of the Land Use Committee? Who is on the committee? Who's the chair?
Supervisor Marr is the chair. Supervisor Wiener and Supervisor Cohen are also on the Land Use Committee.
Okay. Did Supervisor Marr or anybody else on the committee move for a continuance of that matter?
I do not know. I am not the staff person that staffs the Land Use Committee, and that staff person is no longer with our office, and so I don't know the answer to that.
Member Nee, were you asking if there was a request for a continuance at the hearing?
Well, if any of the members of the Land Use Committee moved for a continuance, given that the 14 pages came in last minute, I think it's the fact that they went ahead and voted on it anyway is relevant to our discussion here.
I did watch this. I watched the whole thing, but I did it a month ago. And I know there was some discussion as to whether they should be voting on it or not, but they did not continue it. Member Costa.
I actually had a similar question, and I think mine was more along the lines of, given Supervisor Marr's concern about this matter, particularly with regard to the Sunshine Ordinance, why there wouldn't have been at least the suggestion that perhaps the item should be continued.
I can't speak to that, but all I can say is that Supervisor Marr voted against the amendments, and he was outvoted by the other members on the committee.
Member Snyder?
Ms. Chen, so if Supervisor Marr is not the correct subject of the complaint here, who do you submit should have been? He is the chair of the committee, correct? And the complaint is against an action of the committee.
Okay, but the complaint, as I understand it, is in regards to these 14 pages of amendments that were introduced by Supervisor Chu.
Right, but it was the committee that voted on those amendments, and I think the complaint is, if I'm reading it correctly, complains about an action of the committee, and ordinarily the task force requires that that a person be named rather than just an agency. As the chair of the committee, it would appear appropriate, if a little bit odd, given that he voted against it, would appear to be appropriate that he be named in his capacity as chair of the committee. Do you disagree with that?
I respectfully disagree.
Member Washburn?
Yeah, I don't think it matters how Supervisor Marr voted. The issue is whether he should have proceeded with this matter. And he correctly noted that there was a sunshine problem here, and because there was a sunshine problem here, the matter should have been continued. And how he voted is immaterial, I think, to our deliberation. We're here to determine whether or not public meeting requirements were violated, and it looks to me like they are.
Member Nee?
I have a question that perhaps Mr. Threet would like to weigh in on. Ms. Chin has noted that it was for sunshine reasons that Supervisor Marr voted against approving the document. And so my question is, although Supervisor Marr is named as the respondent in this complaint, could this task force appropriately substitute names of Supervisors Wiener and Cohen, and perhaps Supervisor Chu? Could we take it upon ourselves to substitute those names as respondents?
Through the chair to Member Nee, I think there's several levels of question here. It appears to me that the complaint is appropriately lodged against the committee, as Member Snyder pointed out. It's the action of the committee in continuing to hear this item without a continuance so that the copies could be distributed to the public and they have an opportunity for public comment. That's the source of the complaint. So it's the committee's actions that are at issue. So the question is which members, if any of those of the committee, can be held responsible by the task force. There might additionally be a question as to when the Board of Supervisors as a whole took action, whether that was appropriate under these circumstances as well. So Board President Chu was not a member of this committee. I think in analyzing who is responsible for the actions of the committee, he would not be an appropriate respondent. And the question of who is responsible for the committee's action, I think, depends on what was the exact action of the committee. If there was a motion to continue and Chair Marr voted in favor of it and he was outvoted, then it would appear that the appropriate respondents would be the two members who voted against the motion to continue. But I don't know what happened at the committee. I don't have any facts that would suggest how to analyze that.
Ms. Chin, do you happen to know if the Land Use Committee, if the matter went before the full board yet? Has it gone before the full Board of Supervisors yet? Do you know?
I'm sorry, I don't know. This is not, my staffing responsibility, and unfortunately the person that was staffing is no longer working in our office.
So you don't know if the matter has been approved by the full board or not?
I am
It
not
went before the
familiar.
board
I
the
can't
same
speak
day.
to it.
Okay. Perhaps the complainant could tell us? Do you happen to have that information as to whether the matter has gone before the full board, and if so,
Yes,
what was?
therein lies a part of the other half of the complaint. And as stipulated, Supervisor Marr did vote against it. However, he was outvoted, and the complaint was forwarded that same day, within 2.5 or so hours, to the full board, and they did not have enough time to read the 14 pages. As was stated, it would be in the video from sftv.gov. It's there.
Did the full board vote on it?
Yes, they did. It was a very contentious vote, and the 14 pages dominated much of the meeting, but they did vote on it, even though not all of them had read it.
Thank you.
And just to point out, I don't remember which member it was, but they did. Supervisor Campos made reference to whether it had been properly submitted under the Sunshine Ordinance at that time. And I did watch the video, and it's my recollection, perhaps one of either the attorney or perhaps after Gavin, I don't recall them actually making a motion to continue it. There was some discussion about it, and Supervisor Chu apologized for the delay and was saying that he understood, but I don't recall there being a motion to continue. In addition, there is one other thing that from the video that I wanted to ask about. There are two. Did the members of the public know about the very substantial amendments, the other set of amendments, the things that were talked about the, there was some amendments that had to do with the PUC having control over
No,
what energy?
that comes later.
Did-
I saw that meeting. No, we did not know.
You
We
did not
didn't.
know
We
about
didn't.
those?
We did
Because
not know
they
about those.
introduced those in the same meeting as the tenants' rights ones that Supervisor Chu introduced. But
Well, a part of what has happened with this process, it has been like a locomotive without a driver. And as we are learning our rights under the Sunshine Ordinance, but the one that, and this is historic for us to even be here today to talk to you, and the one that I caught as myself was the reference from Supervisor Marr and Campos about the Sunshine Ordinance, and that is when I went on the computer to find out what that actually meant. And then I also met with Mr. Rustin to explain that the other people who were on the committee, the complaint was more so with them as opposed to Supervisor Chu, but he was the chair of the Land Use Committee, and it was there that these phantom 14 pages are introduced and forward on. So they have for the procedure they use, it started with the Land Use Committee meeting, and then they went before the board that same day.
And then just so I can be very clear, not everybody received a copy of the actual text of the 14 pages.
Yes, that is correct.
Did anybody receive a copy?
No. None
No,
of the
just
tenants.
the
I
summary?
cannot speak to maybe some of the tenants' rights or some of the attorneys may have been there, but in terms of the people who actually live there, they were only given this 2-page summary.
No attachment.
And no, there was no attachment provided until after they had voted on it, and that was like a week later.
Thank you. Is there any further? DCA 3?
Through the chair, just to further respond to Member Kenny's question, assuming the facts are that there was no motion to continue and that the task force believes that this should have been continued under the Sunshine Ordinance, then I believe that any and all of the members of the committee could be named as respondents.
Thank you.
Member Costa?
So I was just looking at the minutes, and to my eye, it doesn't look like there's any sort of vote on a matter of continuance. I don't know if that, I guess it's possible that there was a motion and it wasn't seconded, but I don't see anything in the minutes.
And I have a question to DCA 3. In order to continue this, is that something that has to be voted on by the committee as opposed to just the call of the chair?
It does have to be, well, if the chair says without objection and there's no objection, then it doesn't require a motion. Otherwise, it would.
Okay, thank you. Is there any further discussion among the task force?
Also, if I may.
You'll have a chance in a moment. I'm just
still learning.
making sure I got all my. Okay, seeing no further discussion, the respondent and then the complainant will each have 3 minutes to respond.
My position is still the same, that Supervisor Marr did not have any advance notice of these 14-page amendments. He voted against them. I think it is clear by the way the vote went down that had he made a motion to continue, he would have been outvoted and the amendments would have gone forward and the result probably would have been the same. But let's just be clear that Supervisor Marr did vote against these amendments.
Complainant?
We are not here today to stop the development of the Park Merced project between the City of San Francisco and the Park Merced developers. We are here because of a procedure. In 1999, the Sunshine Ordinance was strengthened to give more protection for the public to have access to local government. It encompasses laws from the Brown Act and the California Public Records Act. It empowers the public to have access to public information and records so that they can have transparency and accountability from elected officials and city officials. Sunshine Ordinance Section 67.1, Section E. The public officials who attempt to conduct the public business in secret should be held accountable for their actions. Only a strong, open government and sunshine ordinance enforced by a strong sunshine ordinance task force can protect the public's interests in open government. You are the residents who are the guardians of local government here in San Francisco. Your voice gives the sunshine ordinance power that protects all of us. I have here a calendar of May, if you excuse me, I didn't put May. But looking at the timeline, it was mailed, the agenda was mailed on the 13th. It was published in the newspaper on the 17th of May. And then here we have.
Could you stay in front of the microphone, please?
We just need to hear it for the record.
It was okay on the 13th.
Could you put it in the projector, please, so that the entire assembly can see it?
It's kind of big.
Well, I'll tell you the dates. On the 13th of May, it was the agenda was mailed to the residents whose homes are going to be demolished, and it was also sent to the newspaper. It was published on May 17th. On May 20th, it appears on the Planning Department's website that it's a revision. The development agreement has been revised 7 times prior to May 24th, so another continuance would not have heard it. And so we have a question mark because if it's on the Planning Commission's website, May 20th, the clerk of the board and the committee gets this report, get these phantom 14 pages on the 24th. And in the tape, City Attorney Sullivan says he works on them the night before. So we have a violation of the 72-hour agenda right there in his own words, and just dealing chronologically with the facts that I could support in terms of being published, the newspaper, and so on and so forth. And we are all very concerned as to how this happens because this decision you reach tonight sets a precedent on how things are added to the agenda, and no supervisor should be under duress and forced to vote on something that they have not read. Thank you.
Thank you. The matter is back with the task force. Member Neem.
Madam Chair, besides the sections, particularly 6715 mentioned by the complainants and speakers in the complainant's behalf, I also believe there was a violation here of 67.7B, which reads in part, the description of an agenda item shall refer to any explanatory documents that have been provided to the policy body in connection with an agenda item. That requirement apparently was not met here. I see a violation of 67.7B. Madam Chair, I move that we find the Land Use Committee of the Board of Supervisors in violation of sections 67.7B and 67.15A and B, and that this matter be referred to the Ethics Commission, naming Supervisors Wiener and Cohen as specific violators, willful violators under 67.34.
Is there a second?
Second.
I believe Mr. Threed had a comment.
Do you see a threat?
Through the chair, I want to clarify the advice that I gave. I do think that the individuals named in Chair Kenny's motion are appropriate respondents for this motion, assuming that there's a violation as the facts have been laid out. However, Supervisors Wiener and Cohen were not named in the complaint and have not been given notice and an opportunity to be heard here. So I think in terms of an order of a determination, that's a different issue, whether it's appropriate to hold them in violation tonight. Supervisor Marr has had the opportunity to appear here and give his defense, but the other two have not. They may have different defenses. They may have other things they want to offer.
And
if I could just really quickly say to the task force, having watched this video, two things. Supervisor Marr, as chair, was acknowledging that he knew that the Sunshine Ordinance was being violated potentially and made no motion to continue. And to me, that is, not complying with your responsibilities under the Sunshine Ordinance. Secondly, one of the things that happened is that throughout the entire meeting, all Supervisor Marr can say is, we've got to get this public comment out of the way. There are repeated times when he complains about how long public comment is going. In fact, during public comment, he makes the comment that you'll have a certain amount of time, but please don't take it all. So that, to me, is adding to the problem that these people did not have an opportunity to speak about this. It's when you're a member of the task force and you see it, it's not part of their complaint, but I feel that it adds to it because they didn't have time to speak. It's really egregious, and it is repeated over and over again. And in fact, there was a pension reform meeting that happened out in front of City Hall with Mayor Ed Lee, and Supervisor Marr continues to press the public to hurry so that they can have a recess to join Mayor Lee out front. So they actually recessed this meeting to go to this press conference out in front of City Hall. So I feel like with all of those things combined, I would not leave Supervisor Marr off. I feel like he acknowledged that he knew that the Sunshine Ordinance was potentially being violated, made no effort to stop it, though he did vote against the amendments. He didn't really make a motion to continue them. So I just wanted to throw that out there, having watched what occurred. Member Snyder.
I'll pass. My comment is...
Member Need.
Well, I am willing to accept an amendment to my motion then, friendly amendment to add Supervisor Marr's name as chair of the Land Use Committee.
Would the second accept that?
Well, but you're adding his name to two names that Mr. Threet said we had not given them an opportunity to speak. So I would be happier if the amendment were to solely name Supervisor Marr.
Chair accepts.
The maker accepts?
The maker, I'm sorry. Oh, boy.
I'll accept it too.
Force of habit is
whatever
right.
you want to do. Does the second accept and then DCA 3?
Maker accepts.
Does the second accept?
Yes.
And then DCA 3?
Through the chair, in the interest of providing the task force with as many options as are possible for you to achieve what appear to be your goals, if the motion is to add the two other supervisors, one option may be that you split the motion slightly so that you add them as respondents and continue the portion of the hearing that names them to the next meeting so that you can, there's not the requirement that the complainant file a whole new complaint against them in order to hold them responsible. Then you could act tonight on finding Chair Marr responsible for what you find his actions to be, and then the other two supervisors could appear at the next meeting to present their case.
Madam Chair.
Member Nate.
Let me, in that case, amend my motion this way, moving to find Supervisor Marr in violation of sections 67.7B and 67.15A and B, removing, for the moment, the referral to ethics, and requesting that the chair once this is voted on, requesting that the chair continue this item to add Supervisors Wiener and Cohen as add their names as respondents, and continuing the hearing to our next regular meeting, which is September 27th.
Is that a substitute
That's-
motion?
You can call it a. I
Dividing
guess
them?
you'd call it substitute or amended.
Second.
I guess
Because we're dividing it?
Well, okay. Well, we're dividing. We are dividing it. Number one, I guess it is a substitute motion, so it would require a second.
A new second.
A new second. The substitute motion is to find Supervisor Marr as chair of the Land Use Committee in violation of sections 67.7B and 67.15A and B. The second part of my motion would be to continue this matter to our next regular meeting, adding Supervisors Wiener and Cohen as respondents.
Is there a second to the substitute motion? Second. Okay. Is there discussion on the motion? Seeing none, is there public comment on the motion?
Task Force members, Ray Hartz, Director, San Francisco Open Government. I want to congratulate you. I think that the motion before you is excellent. It acknowledges the fact that the person chairing the meeting raised the issue of sunshine, and it was disregarded not only by the other two members, but ultimately ipso facto when they voted on the motion. They were basically ignoring the fact that we had discussion that there was a potential sunshine violation, and we decided just to ignore it.
Thank you.
Good evening, Task Force members. Thomas Piccirillo. Where is the accountability for President Chu? President Chu is the one that introduced the 14 pages of documents. The fact that he's the president of the board, running for mayor, you shouldn't be intimidated. You should go after the people that are accountable for the lack of due process. So you need to send President Chu a message and continue the matter and bring him or his staff here next month and explain why the 14 pages were introduced without public comment. Thank you.
Thank you. Is there additional public comment on the motion?
I agree with some of the sentiments of the previous speaker, but I am still a little bit confused. It seems to me you've thoroughly discussed the heart of the matter and the complaint against Chu and Marr, and you should be voting on that today, making a decision on that today, because you've thoroughly discussed it, and then carrying on the rest of it next time. But you've already decided, at least if I hear the spirit of this committee, that Chu and Marr are in violation of the Sunshine Ordinance on the matter before you, and I wish you would vote on that and then move on to the other matter next time. Thank you.
Thank you. Is there additional public comment? I'm sorry, since you spoke on behalf of the complainant, I'm sorry, but thank you. Is there additional public comment on the motion? Seeing none, the matter is back with the task force. Is member, you look like you were. Member Washburn?
Yeah, you saw my facial expression. I think member of the public, Piccirillo, raises an interesting situation with regard to Supervisor Chu, who brought the 14 phantom pages to the committee in the first place. And then a couple of hours later, the Board of Supervisors voted, heard this matter and voted on it and approved it. So I'm wondering if perhaps we couldn't continue this matter, not the whole matter. I think it's time to send Supervisor Mars our disposition with regard to him. But I think we might consider bringing Supervisor Chu here to hear this matter.
He's already named.
Member Nee.
With due respect to Mr. Piccirillo's sentiments, I agree with them, the sentiment. However, in the documents that we have before us, the only named respondent is Supervisor Marr.
However, on the agenda item, it's both Chu and Marr.
Well, the agenda item misspeaks. Excuse me, ma'am.
Is Mr. Rustin? Is it an error that Supervisor Chu is on there
Madam Chair,
on the agenda?
I purposely put his name on the agenda with the agreement of the complainant.
And I know that Supervisor Chu's office responded, saying that he didn't believe he was a respondent. Is that correct?
That is correct, yes.
Member Snyder?
So the section of the Sunshine Ordinance that we're saying the committee violated is lays out the requirements for agenda items. And so what I think we're saying is that the agenda for this meeting was faulty because it didn't and couldn't have really adequately explained what the content of the agenda item was, because this last-minute addition to the agenda item changed it in such a way that the agenda item didn't adequately notice it. This is kind of a technical argument, but I don't see, based on that violation, how we can hold Supervisor Chu responsible here. He's not a member of the committee, right? Or am I missing something? Because we're finding that the committee, I mean, I understand the outrage, and I understand the basis to want to find Supervisor Chu in violation here, but if he is in violation, it would need to be of a different section of the Sunshine Ordinance. He's not responsible for the committee's actions with respect to creating the agenda, and the sections that we're finding a violation of have to do with the agenda. We're saying, in essence, the agenda didn't adequately describe what was going on, because it couldn't have, because this thing was dumped at the last minute and it substantively changed it. That's probably a discussion for the later meeting if we decide to add Supervisor Chu as a respondent later. So maybe we could add him now and then discuss this issue at the later meeting, but I thought I would just raise this issue.
DCA Threet and then Member Nee.
Through the chair, assuming that the committee has heard evidence during this hearing that implicates the actions of the Board of Supervisors at its later meeting considering this item, and whether the agenda for that Board of Supervisors meeting was adequate. If that is the case, then it would be possible to add Board President Chu as a potential respondent and continue the item to consider that more fully and give him a chance to respond.
Member Nee?
Well, yeah, Member Snyder is correct, but again, in the complaint itself and in my motion, Member Chu is, Supervisor Marr is the only named respondent here. Perhaps the second part of my motion could be amended to add Board President Chu to the continued portion of this hearing.
Well, based on having watched the video myself, it was pretty evident that they were concerned about the sunshine. I did not watch the vote with the full board, but DCA Threet's comments do lend themselves to the idea that Board President Chu was aware that this could be a sunshine violation and potentially did not do anything to, under his requirements under the Sunshine Ordinance to prevent that at the board. I didn't watch the full board vote, though.
Well,
Was there any discussion?
I believe that one of the members of the complaining party did mention that Supervisor Campos raised that precise objection during the full board meeting.
Yes, that's true.
So if the second accepts.
Actually, Member Nee, before you, I have a proposed friendly amendment to the first half as well. Maybe we could do this in one lump sum if that's acceptable.
Please.
So I would just propose just to add a little bit of our reasoning for the violation to the actual motion. So the wording I would suggest is to tack on to the end of the first half of the motion where we find the violation for the sections that you noted, Member Nee. I would say those violations for failing to adequately notice the substance of the relevant agenda item based on the last minute and substantive changes to the item created by the 14 pages of amendments.
Could we throw in the word known, the known last minute? Because I think part of what we're saying is that Supervisor Marr admitted that he knew, he was aware that there could be a violation. Is that implied in within?
I think that's implied in
okay.
that.
Second accepts?
Yes.
Maker accepts.
So Member Snyder had mentioned the friendly amendment for both. Are you then adding Supervisor Chu to the second half? Or is that just to
if someone else wants to do that, I would probably go along with it. I'm not sure that wasn't part of my suggestion, but someone else.
So
Madam Chair, the maker proposes adding the name to the second part of the motion, adding Supervisor Chu as a respondent.
The second accepts.
Is there any further discussion on that? Is there public comment on the motion as amended? Seeing none, I want to clarify that we have the motion correct before we vote. We're moving that we find a violation of 6715A, 6715B, 67.7B against Supervisor Marr as chair of the Land Use Committee.
6715A and B.
A and B, 6715A and B. And for failing to adequately provide an agenda based on the last minute agenda changes. I'm not saying that will be the exact wording, we'll use yours, but I'm just trying to clarify it. And then the second part of that would be to continue to add Supervisors Wiener, Cohen, and Chu, and continue that portion to the next meeting with the same violations.
I believe that's correct.
Mr. Rustin, will you please call the roll?
Yes, Madam Chair. On the motion, Member Snyder?
Yes.
Snyder, aye. Member Nee?
Aye.
Nee, aye. Member Washburn?
Aye.
Washburn, aye. Member Costa?
Aye.
Costa, aye. Member West?
Aye.
West, aye. Member Johnson?
Aye.
Johnson, aye. Madam Chair, we have 6 ayes. The motion passes.
Okay, so the second part of the motion to add Supervisors Wiener, Cohen, and Chu is now continued to our September meeting for those violations. The violation against Eric Marr, we can refer that to committee, or does it need to come back here?
Well, the committee referral is at the call of the chair. However, I would question what the purpose would be of referring it to committee. My own suggestion, I'm not sure at this point that referring this matter to committee at all, even at the close of the next portion, the continued portion, would serve any purpose. The violation is there, it's done. My suggestion would be once we have concluded this matter, assuming that we will also, assuming for the moment that we will also find Supervisors Chu, Wiener, and Cohen in violation, I suspect that we will want to refer this to ethics.
Well, so then we'll put the order of determination against Supervisor Marr as its own item on the next agenda. Thank you. Pastor Gavin and the people who are here to support you, I do appreciate your patience from last meeting and your patience this evening because we started late. At this time, we generally take general public comment for items not on the agenda at 5 p.m. However, is Mr. Maxwell present? Yes, ma'am. Is the gentleman, I'm sorry, I've forgotten your name, present from the MTA? Mr. Maxwell, the MTA has requested a continuance because they believe they have documents responsive to your request. Are you opposed to a continuance, or are you... Can you do the mic? I'm sorry.
Please.
I'm opposed to it because they had an opportunity to come last meeting and no one showed up. Here it is, the next meeting, now they're trying to wiggle their way out of it. This matter needs to be addressed so we can move forward where the members of Local 250A needs to go forward with. And this matter needs to be heard and addressed today.
So, Mr. Maxwell, I'm not sure exactly what I'm trying to say. The document they're asking for, a doctrine of waiver, is interpreted in law as sometimes not. The doctrine of waiver is not always a singular document, and it's not always a series of documents. In fact, it can sometimes be actions. It can be behavior. So my concern, if they're telling you that they have, I hear what you're saying, and I appreciate what you're saying after all the things we've been through with the SFMTA, but I'm just trying to make sure that you get what you need, as opposed to just having a hearing where we find that they didn't turn over any documents. Because it's not, if there's documents that they can provide to you that they say support that issue, then it might be easier for us to tell whether they're actually speaking about something that's available to you or more just a policy that is something within the legal field that a group agrees on. I don't know if that... Have you discussed with the representative MTA what documents they have for you?
No. No one has communicated anything with me except Carolina Celaya back in June. And only thing she gave me was a partial partial of my request, but it was other things pertaining to my request that was also asked for.
Do you have documents today? Is this something that we could have public comment about and you could possibly look at them and see if a continuance would be helpful to you while we're having general public comment?
I'm for it. I'll look at them and then make a determination from that point.
Okay, thank you. So at this time, we're going to have general public comment on items not on the agenda. Is there any public comment on items not on the agenda? Seeing none, public comment is closed. Has that ever happened before?
Not to my recollection.
Okay. I'm going to give... you have 5-minute recess. Should we do a 5-minute recess?
Madam Chair.
Member Nee?
Might I suggest then, in the absence of general public comment, and in order to give the complainant and respondent in item items number 6 and 7 time to get with each other and decide how they want to move forward. I would suggest we, in the meantime, move ahead with item number 3. That's my suggestion.
Okay. I agree with that. Let's. Oh. Mr. Rustin muted the language. Mr. Rustin, will you please read item number 3?
Yes, Madam Chair. Item number 3, file number 11043. The Compliance and Amendments Committee has referred case number 11043, Alicia Gomez against the Public Health, back to the full task force with a recommendation that it find all noise ordinance task force meetings, recommendations, and documents invalid, and monitor DPH compliance with the committee's order to produce records based on the order of determination.
Is the complainant present? You have 5 minutes to discuss your order of determination.
I'd like to thank the task force for the order of determination. Can you hear me? Okay. Can you hear me?
Yeah.
Okay.
Thank you.
I'd just like to thank the task force for the order of determination. The noise ordinance task force has been meeting for about 3 years now with absolutely no public comment. I appreciate that that there is this body to resort to upon finding that this was the case. I will further add that regarding document production to date, the department has begun to produce some documents. They've also apparently elected to not produce others. For example, I've asked for certain attorney comments, and they, instead of providing me a list and any reasons why those documents were not being produced, said you can just communicate with the city attorney's office directly for that. I don't know whether that is an acceptable response for them. That would just start a whole new process, and if they have documents in their control, my understanding is that they either must produce or give a reason for not producing, an appropriate reason for not producing. I will also ask that you look at the timeliness of their response regarding document production. I have been asking since last October. I don't know when the order to produce, I'm not sure if that's the right term, was given subsequent to the committee meeting that was held the other day, about a week and a half ago. I received them last Thursday, the first of what I hope will be more document productions. Last Thursday, I don't know whether it was timely or not. My understanding, it was supposed to be 5 days, and I don't know if those are calendar or business days. But in any case, in the grand scheme, they're very tardy. I've been asking for a long time, and I've only just begun to get substantive responses to my requests. So, again, thank you for your diligence. Thank you for your enforcement. Without it, this noise ordinance task force would have completely shut the public out in totality from its conduct. Thank you.
Thank you. Is there anyone present to present facts and evidence in support of the complainant? Seeing none, is the respondent, either respondent or both present? You have 5 minutes to address the order.
Dr. Rajiv Bhatia, Director of Environmental Health, representing the Department of Public Health. To the task force's determination or order with regards to the noise ordinance task force, there are no objections from the department to the order, nothing else to add. We've admitted our responsibility before. With regards to the failure to produce documents, I object to the order of determination. I think it is not based on any fact, and I'm going to try to provide again the record here and ask you to reconsider your decision. I think that Ms. Gamez's request started in October of last year. There were interrogatories, requests for explanation and information. We spent countless hours, dozens of hours, talking to her on the phone, writing emails to respond and explain to her the enforcement of the ordinance. We provided those documents back to her because they were documents. We've provided them to you, and they are part of the record. On May 6th, she made her first official document request. It was very specific. It was for a statement of policy of procedures that did such and such, that had certain purposes. We told her at the time we had no statement of policy and procedures. We still don't. And but yet she didn't accept that determination. We told her that a document was forthcoming around guidance to restaurant staff on how they manage complaints. We provided her that document when it was developed. We subsequently had the order from you. I reviewed that order. Again, we don't object to the noise task force issues. However, I looked at the order, and you find that the department and I have prevented documents. You haven't named any documents, identified any documents. You haven't told me how I prevented any documents. And I would maintain we always provided all the documents that were responsive to the request. I came to a committee meeting where you advised me to meet with the complainant or ask her how we could provide her more information. We did so. She provided 4 new document requests. Two were very specific, two were general. I will get the example of the general request is anything at all that sheds any light on the noise ordinance. As I think that's a very general request. It's not a specific document. Nevertheless, we produced the 2 specific documents. We helped her, coached her to identify other documents that may be helpful to her or interest. Those were records of investigations and compliance letters for the noise ordinance. These show the measurements and how we assess the measurements against the standards and how we take action. So I provided her 5 records. I provided her that were representative examples. And I would maintain this was a new request. Not the old request. I mean, so let's please not confound each one of the requests. The first period of October to May of interrogatories, which we responded to fully. The May 6th official request, where there was 1 document we subsequently created and provided to her, and the sort of subsequent request to this to my committee meeting, where we helped her identify additional documents. So I provided her those additional documents. It takes time to clarify the request, identify the documents, redact personal confidential public health information from the documents, and get them to her. The response from the complainant to our helpful, what I would say is helpful document production was, please provide every document, every inspection report, and every enforcement letter with regards to the noise ordinance. So it's not clear to me what the complainant is looking for. It is, and we will be providing her. We will be going through every single noise ordinance enforcement investigation report, every enforcement letter. We will be identifying them. We will be redacting personal and confidential information. We will be providing for them. I will provide it to her on a weekly basis because this is a lot of requests. I have department staff who actually have to do enforcement work. And we will continue to do so. If we ever produce a guidance document which is responsive to her original request, she will be the first to get that document. I have no objections to providing documents. I have always provided the documents. I do have objections to being found at fault when I have been providing the documents. Subsequent to the last meeting, I also asked your staff person, please give me the facts and evidence that you used to find that I was in violation. If I look at the order of determination, there are no facts and findings in the record that support your conclusion. There's the testimony from the 2 parties, but there are no facts. There are clear facts regarding the noise ordinance task force, but in your record there are no facts regarding the your latter finding. So if there is a document you would like me to provide, if anyone would like me to provide, I'm very happy to do it. We always do that, and we will continue to do that. But I'd like you to correct the record.
Thank you.
Action evidence.
Well, there were 2 separate competing issues. I wanted to make sure that Mr. Rivard, is that didn't want to say anything about the noise ordinance task force since you had appeared? You're okay. Thank you. Is there anybody to present facts and evidence in support of the respondent? Seeing none, the matter is back with the task force. Member Washburn.
I'd first like to address the matter of the noise ordinance task force and the fact that it violated every measure of the sunshine ordinance. And I believe that one thing we wanted the department to do was to come before us today and explain what you were going to do to remediate this problem, because we had determined that any action that you took while meeting in violation of the sunshine ordinance, those actions would be void.
Respectfully, the task force took no actions. The task force was discussion and deliberation among city staff. They made no policy recommendations to the board. We will have another meeting. The meeting will focus, I think, almost extensively on the opportunity for public comment on the workings of the noise ordinance. And if there is a demand for further meetings, if there is public interest, we will have another meeting. We are very interested in getting the public involved in the development, enforcement, compliance of the noise ordinance, and we would love the more people engaged and involved, the better. If you have any other specific suggestions, we'd be very happy to implement them.
Thank you. Member Name?
Dr. Bhatia, I believe you mentioned that the Noise Ordinance Task Force is due to sunset on September 13th. Is that correct?
That's correct.
Okay. What if... give us, please, an idea of the funding situation. What happens if, as of September 13, you discover that really the business of the Noise Ordinance Task Force is incomplete? Do you have the option of continuing beyond that sunset date, or what's going to happen here?
If there's a substantial interest by members of the public in the Noise Ordinance Task Force continuing, we can make that recommendation to a member of the board and ask them to continue it. In my view, the reason we were involved in developing the ordinance, the reason we created the Noise Ordinance Task Force was here was an entirely new way of regulating noise in San Francisco. It hadn't been changed since 1974. We needed to get all the city family who enforces the noise ordinance on the same sort of page with how to enforce it. So the major substantive need, the purpose of the task force was interagency dialogue and deliberation. I apologize that wasn't made, that those dialogue and deliberations weren't public, but the major need, I think, has been met.
Member Costa.
But so you're telling us that there were no determinations made by the task force of what those enforcement policies should be?
No, we were enforcing the policy of the board as written. We were taking areas where the public had made, where there were high frequency of complaints. So we get complaints, and we were using that public information to prioritize where we focused our actions, for example, on motorcycle noise.
But I guess what I'm asking is, there were decisions made at these meetings about where to prioritize actions.
Now, that's what I said. I mean, the priority of actions came from there was an existing sort of agenda of what public people were complaining about. We were discussing and deliberating how do we coordinate our resources. There were no actions taken by no policy actions taken by the task force.
Thank you.
Thank you. I would like to address Ms. Gamez had mentioned that she was wondering if there was a violation at the for not turning over the documents in time. But at the Compliance and Amendments Committee, we did say we would give them the full 14 days to today because we had failed to put the 5-day order actually literally in the order of determination. So it would be difficult to go back on that, stating that we're having them appear again, and they were going to be here anyway. So we had given them the full 14 days, and you feel that they did provide you some additional documents.
Yes and no. Some of the documents they have produced a sample of cases, I guess I'd call them. They have cases, meaning places where I guess there were some complaints. They provided me with some paperwork related to my own case that had never before appeared. So there may be one file with 13 pages, another file with another 13 or so pages is what and then two separate little 1 or 2 page PDFs. I mean, they're all PDFs, but so a total of 25 or so pages, I'm not sure.
And you understand that Dr. Bhatia has discussed providing you documents on a rolling basis, which is allowed under the Sunshine Ordinance?
Sure, okay. But he has specifically directed me elsewhere for documents that are in his control without giving me a reason for not producing them. And I will go back and say that my May 6th request, the formal sort of technical one, was the very broad one where I asked not for a specific only a policy procedure, but for anything that would give light on what the department does, any policy, any procedure, any manual, any training, any email. Dr. Bhatia does claim that in the entire 3 years of the ordinance's existence, there has never been a single email instruction of any kind, no document that gives any instruction to any employee, no written documentation of how to enforce the ordinance at all. I find it a little bit regarding the noise ordinance task force. It's very funny because he claims that there were priorities and that they deliberated on priorities, and that the departments, I guess there were no decisions made but actions taken at the department levels. I mean, it's very odd how he's characterizing what the department did. I will further add that had there been public comment, no doubt there would be a different form of conduct at this point, and that the public would have a very different relationship with the noise ordinance and with the department.
And then I just wanted to address one more issue. It's just to make things very fair and clear. Your subsequent document requests would be that he had mentioned, Dr. Bhatia had mentioned that you had requested, you made 2 new, I believe it was 2 new additional document requests.
I don't believe that anything the new things are only hashing out the technical one on May 6th.
You're providing clarification for
yes,
for those.
And saying, another example of, for example, there were previously we asked for everything related to the noise ordinance, my case, right, and the case that my neighbors have. In specific, there was one in which one letter that had been that was produced that was referenced in an email back in exchange, and I had previously asked for that specific letter to be produced. So that specific, I guess you could interpret that to say that's a brand new request. It's actually part of the old request. It's just that now I have a specific date and email letter cited that, I think it was the April 5 letter to so-and-so. I cited that.
Okay.
That sort of thing. But
Thank
I don't believe that anything that I've asked for was new as of May 6th. It was, only being more carefully targeted and directed so that they would respond, I guess is really what I would say.
Thank you. Is there any further discussion on the task force. I think at this time, the respondent and then the complainant will each have 3 minutes to clarify or respond.
Yeah, I appreciate you do a very challenging job. And I'm an environmental regulator. You're trying to enforce the law. I'm trying to enforce the law. I think as a regulator, what I have found very challenging in regards is that I'm doing my best to adhere to this law. I have for 12, 13 years. I know, again, noise ordinance task force issue aside. There are specific requests, and there are documents that the department produced in those requests. It's not clear to me that anyone has actually evaluated, read the request from the complainant, and seen whether the documents that were provided in a timely fashion were, in fact, meeting the requests. You're treating the opinions of the complainant as fact. And I think you need to be independently evaluating whether her original request was different or the same as the subsequent requests in making your determinations. And I have the request right here. I've requested a statement of policy or procedures other than the noise task force that the Department of Public Health uses to implement the noise ordinance. The statement could be an email, memo, training manual, blah, 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 any other kind of documentation that does or any or all part of the items described below. And then she describes a set of functions that the policy and procedures can relate to. Now, an inspection report, an enforcement letter for a complaint at this restaurant or that restaurant is clearly different than this request. We have many ordinances. We have many documents related to the ordinances, and I think we deserve some specificity when we're being asked to produce documents. We think, in my own view, I think that the complainant wanted to understand how we were doing things and why we were doing things and sought information for that purpose. I think we really tried to provide her that information. If you're going to find us at fault, please look at these requests literally, and see whether the documents we provided at multiple time periods over this course were produced and whether they were produced timely. If you're going to cite me for 4 or 5 different violations, prevention, untimeliness, withholding, please let me know what I did wrong and exactly what facts you have to support that. So, because otherwise I feel my due process is being violated here. I appreciate you do really difficult work. I appreciate that it is important for this stuff to be public. But I also have, I think I should also be treated fairly here.
Thank you. The complainant will have 3 minutes.
I will only say that since October I've been asking for information. Since October I have been consistently told that there is nothing that meets my request. In May I made the request in a technical format after having cited the noise ordinance. I disagree that as I said originally when I was here at the task force, originally it could have been a code citation and a case, anything that would just give them authority to completely supplant the code as written with their own interpretations. Nothing has ever been forthcoming to provide that. They have been rewriting the code without any basis. As they have, and they continue to now say, as I said, there is nothing, no guidance, no procedure, no email, nothing at any point that at any time describes actually their implementation. And therefore, and in my request, the part that he said blah, blah, blah was actually my saying anything that any policy procedure that implements the code, any email to communication, any video, any handout, anything, any report that does it. In the absence of any even ad hoc direction, you look to the reports that are produced as a result of it. The reports are the only thing that are responsive at this point. And unfortunately, because of the way they do their business, and they have absolutely, they claim, nothing to show anyone who would like to see what their policy is, the only thing you can look to are the reports. And the reports bear an arbitrary relationship to the code. And so now I'm looking at the reports, and he's saying that no one's ever looked at I've looked through the reports quite consistently, and, you know, the original production that happened subsequent to the May 6th request was marginally, I mean, it was almost all my email to and from them. I thought it was kind of dismissive, kind of a little bit of contemptuousness towards my request. Subsequently, more information has come forth, and I appreciate that now, because of the scope and because they have nothing even vaguely distantly on point, the scope grew larger, and now it's kind of an investigation on my part to see when, if ever, they actually enforce the code. And that will be part of what I will talk to them about during their last task force meeting. But that will be the last one, and they will then close the books and say, thank you very much, we'll do as we like.
Thank you. There will be an opportunity for public comment, but the matter is currently back with the task force. Member Snyder.
So the purpose of having the parties back to this meeting, I think, was to sort of monitor what the progress was on any further or more detailed document requests that Ms. Gamez had. And it sounds to me like the department and Dr. Bhatia have been making good faith efforts to respond. I'm not sure they've responded, entirely, but it sounds like there's a process underway that Ms. Gamez is receiving documents, and most importantly, that DPH and the Noise Ordinance Task Force understand much better, perhaps, than before, what the requirements of the ordinance are generally. I guess the question for us is to decide what if anything, we do now. My recollection was that we had discussed sending a letter to notify, I think it was the mayor, perhaps the Board of Supervisors, of the fact of these past violations, the past violations that the order of determination recount. We could also refer for willful violations. I personally don't see a basis for that, given that the department and the Noise Ordinance Task Force seem to be aware of they seem to be aware of the violations that happened and they're making their best efforts to remedy those. So I don't have a motion to make, but I just wanted to sort of set the table for discussion about what it is we do next. And I think what we do next is perhaps send a letter to the mayor and the Board of Supervisors. I don't know that there's a basis to do much more than that. The order is what the order is, and it's there. I don't know if there's any reason to do anything further on that order.
I know that at Compliance and Amendments, Member Nee had the motion that was made by Member Nee and that the Compliance and Amendments Committee adopted was to make a recommendation that the Noise Ordinance Task Force work be found invalid. I don't know if we want to discuss that now. It was a recommendation from Compliance and Amendments. I do agree with you that there seems to be much more awareness of their responsibilities under the Sunshine Ordinance, and that it sounds like there are some documents being generated, and perhaps on a rolling basis. Member Nee.
Yes. I'm not sure that any action we take to declare what the Noise Ordinance Task Force has done invalid would really have any force of law. So my suggestion at Compliance Amendments was that we send a letter to the Board of Supervisors, the City Attorney, the Department of Public Health, and possibly the Mayor, urging that any and all actions by the Noise Ordinance Task Force be declared null and void due to public meeting violations. I think that the board and the mayor probably could take such actions and have them, and they would have force of law. We don't have to do that. I mean, I think there is recognition on the part of the Noise Ordinance Task Force, as Dr. Bhatia has already told us. They are well aware of what the sunshine laws are now, and that going forward, they're willing to abide. So we could send a letter, or we could merely thank them for cooperating, and no action would be necessary.
Though our order does, I'm reluctant to not at least inform some overseeing body of what's going on with the noise ordinance. It doesn't have to be declared invalid, but I'm concerned that there would only be an oversight within itself. I feel like we need to at least alert the people responsible. Member Washburn.
I agree. I think that we need to send a letter to the Board of Supervisors, the mayor, the city attorney's office. I think we should make very clear that absolutely all of the sunshine ordinance regarding public meetings was violated from the beginning, and that the situation now is such that there's almost no time for public input before the task force sunsets. And I think we might recommend that the Board of Supervisors request that their work continue for enough time to allow the public to become engaged. We now have some very active citizens who have a lot of input, and so to allow that process to continue, I think we might urge that. And I also, I've said this a couple of times before, I wonder, has this sort of thing happened before? And so I want to just make sure that what we say is clear and loud and forceful to alert everybody to the fact that when these task forces are set up, they have to follow the law. And this is also a matter, I think, of education of the public, which often finds out about these things, when they are up against the wall, like Ms. Gamez and her neighbors were. And I think that public officials often don't recognize what needs to be done too. So there's definitely an education and training function that's part of our purview that we might think of ways to increase awareness on everyone's part of this aspect of the Sunshine Ordinance.
Is that a motion? You're going to make a motion?
I do. Yes.
Second.
Okay, so the motion would then be to send a letter to the Board of Supervisors, the mayor, and the city attorney's office, bringing attention to what has happened, and then urging that the Board of Supervisors recommend the Noise Ordinance Task Force not sunset in September in order to have the public be able to have an opportunity to be engaged with the Noise Ordinance Task Force.
Exactly, yeah.
Okay.
And I think maybe if we can have some language in there, too, to say that, we're concerned that when task forces and other advisory bodies are convened, that they have adequate training so that this type of thing doesn't happen again.
Madam Chair?
Member Neem.
I'd like to propose a friendly amendment to add Department of Public Health to the list of recipients of the letter.
Does the second accept?
Second accepts.
The maker?
Yes.
So then we are adding department. And part of the basis for that, I guess, would be that to ensure when it's not just that whether this is going on or not, but that the Board of Supervisors created this body without realizing that it should be under the Sunshine Ordinance, or to make sure that they check that. Okay. Is there any further discussion on the motion? Seeing none, is there public comment on the motion?
Thomas Piccarello. Yeah, I'm in favor of the motion. I agree entirely with Member Washburn's comments and sentiments regarding this task force and any others that may be rogue and closed to the public. It's unfortunate that one of the task force members of this noise ordinance is a deputy city attorney. There's a deputy city attorney on this task force. So I fail to understand how he or she could not advise the task force the past 3 years, since November 2008, that these meetings should be open to the public and the Sunshine Ordinance should be applicable. Nevertheless, the letter is commendable, and it also should go to the Entertainment Commission, which is also a member of this noise ordinance. Thank you.
Hi, I'm Morningstar Rental. I'm a neighbor. I have 50 complaints from the police department. This is all about noises. This is the letter that I had to go to the Department of Public Health. It was not given to me in person. We requested for it. And this is the one that I just got recently when the letter sent to the owner of the restaurant some sort of improvement. It's the same thing that I had as an inspector. And I noticed that the inspector is more concerned about the compressor, not concerned about the loud music, not concerned about the smoking, not concerned about the fan, the loud fan that had caused vibration into my floor. I haven't been sleeping for almost 9 months now. That's really hard on my health. I'm a cancer survivor. I'm also a patient of UCSF. And when I see that inspector at UCSF, it really hurts me because she's teaching future doctors how to take care of patients like me and how he treated me because he came in with a broken equipment and then lied and said that they did not violate any ordinance. And then I couldn't even challenge it. They've been coming to my in and out of my apartment to get to the rooftop without acknowledging the people who lives in that apartment that don't exist. You know what I mean? So I don't know what to say. And this is all the paperwork I got. This is from building inspector, the violation. For example, what I don't understand is how can someone get a noise permit when there's no mechanical permit? Mean to say if they're not allowed to put that equipment on the roof, that's a mechanical permit, electrical and plumbing. How can someone can get a noise permit when you're not allowed to put that equipment? So I do have a lot of questions. But the hard part about this whole thing is when I asked the inspector the question, I went document, he says he's not willing to give me no documents. And I had to go to public health. And when I go to public health, they only gave me just this little paper. So I had to do my own research, and I had, when Alicia Galmes asked about this question, she's not asking just for herself. He's asking for me and the rest of us who are suffering because we haven't been sleeping for the last 9 months. And it's been very noisy. And I don't know anybody can live like that, you know? And I don't respect Mr. Tom Robert because he lied. And he have put my health in jeopardy. And when I see him at UCSF, and I'm a patient, I'm a cancer survivor at UCSF, and she's teaching future doctor how to help patient like me, it really hurts me because he lied to me. Thank you.
Thank you. Is there additional public comment on the motion? Seeing none, public comment is closed. Is there any consideration of including the Entertainment Commission, or would, okay. Mr. Rustum, will you please call the roll on the motion?
Yes, Madam Chair. Member Snyder?
Yes.
Snyder, aye. Member Nee?
Aye.
Nee, aye. Member Washburn?
Aye.
Washburn, aye. Member Costa?
Aye.
Costa, aye. Member West?
Aye.
West, aye. Member Johnson?
Aye.
Johnson, aye. Madam Chair, we have 6 ayes. The motion passes.
Madam Chair, could I request a brief recess?
Yes. We'll have a 5-minute recess. The meeting of the Sunshine Ordinance Task Force is back in session. I would just like to quickly ask Mr. Maxwell if he was willing to continue the case, if they had come to any agreement.
We came to a partial agreement, but I need to have some guarantees that I need an order of determination issue, so I can be guaranteed that I will have all of the documents that I requested. So
We can't issue an order of determination without having a hearing, so I'm not sure if you're willing to continue it till September to see if you get the documents, or if you're not willing to.
I would like to give them a fair opportunity, but at this point, I think I would like to continue on with it and have it heard.
There's only one case in between. I'm not sure if that's. The respondent would like to have just a moment to say something.
We were out in the hallway and we had a discussion, and I told him I'd make every effort to get him any information that was required under this act, and invited him up to the office, and he told me that he was in agreement on that. The only two pieces of documentation that I had tonight that I thought that he didn't have, I presented it to Mr. Maxwell. He said he had one and not the other, and I said, well, you're welcome.
Pardon me.
Well, God.
Pardon me just a minute.
Yes.
Is that microphone on, Mr. Rust?
Testing 1 2. I'm sorry, I'll move a little closer.
So there's only one case in between your case and the next case, and we're kind of having the hearing now, which I don't want to do. But there is no guarantee, Mr. Maxwell, that when we hear it, you'll get an order of determination. I just want you to know that. So I cannot guarantee that we're going to find for you or against you, or for the MTA or against the MTA. I'm just letting you know that so that you're aware of all of the options. I'm not.
Microphone, please.
They had a letter.
I need a yes or no answer, because you're having the hearing now, and I want to.
I'm not having. I'm just stating that.
Are you saying
the letter that I request is self-explanatory?
Are you unwilling to continue the case to September?
I would like. I'll give him a benefit of the doubt and see what he can.
So I'll put it on the agenda, which will ensure that
I want to guarantee that this here will be fulfilled.
We'll put it on the agenda for September to ensure that it is still being monitored, that you're still on calendar. Okay. So, but you should continue to work together during that time so that we have all the information available for you in September, because I think it's better for you to get your documents that are useful to you. So we'll make sure that you're.
Yeah, because this is I'm basically asking for all documents that's pertaining.
Yeah, I think it was pretty. I think it was clear, and I think that. But I think that.
I'd like to thank the commission. I'd like to thank Mr. Maxwell for the invitation.
Okay, thank you very much for waiting.
Thank you.
So, items 6 and 7 are continued to September. By agreement of both parties. Mr. Reston, will you please read the next item?
Yes,
Item
Madam
4?
Chair. Next item is determination of jurisdiction on complaint filed by William Clark against the Arts Commission for allegedly violating sections 67.22E and 67.21B of the Sunshine Ordinance.
Move to find jurisdiction.
Second.
Is there any discussion? Is there any public comment on jurisdiction? Seeing none, public comment is closed. Mr. Rustin, will you call the roll?
On jurisdiction, Member Snyder?
Aye.
Snyder, aye. Member Nee?
Aye.
Nee, aye. Member Washburn?
Aye.
Washburn, aye. Member Costa?
Aye.
Costa, aye. Member West?
Aye.
West, aye. Member Johnson?
Aye.
Johnson, aye. Madam Chair, we have 6 ayes. The motion passes.
Will you please read the next item, item 5?
Item 5 is hearing on complaint filed by William Clark against the Arts Commission for allegedly violating sections 67.22E and 67.21B of the Sunshine Ordinance.
Is the complainant? Hi, sorry. You have 5 minutes.
This is William Clark. Thank you. I want to give you a brief background of why I brought this complaint in front of you tonight. I'd like to give Mr. Rustum a copy of Section 8 of the Proposition L and also Article 24, Section 2405. What this is in regards to is that 5.5 years ago, on September 21st, 2009, I requested that 4 street art spaces be designated on the 300 block of Hayes Street. And I also requested 2 hearings in front of the Arts Commission to propose this resolution. The first hearing, I requested that there was no vote to be taken and that the merchants from Hayes Valley be present so we could discuss the designation of those 4 spaces. And the second hearing would be a vote on those items at the program committee level. On August, on September 13th, 2006, the first hearing was held, but Mr. Lazar did not notify the merchants to be present, so there was nobody there, and there was just an information hearing that was taken, and no vote on the resolution on the proposal was taken. And then 11 months later, on August 22nd, 2007, we had a subsequent hearing at which the merchant representatives from Hayes Valley was present and opposed the proposal for the designation of the locations. The program committee voted to support the proposal and sent it up to the full art commission the next month, where they voted unanimously in favor of the proposal to be sent over to the Board of Supervisors for a hearing there and for a vote over there. As in the information I gave you, it has Section 8, which is the ballot measure, which contains the language that states it's necessary to be voted on by the Board of Supervisors. Well, what happened at that point was that we waited 21 months from that point, and no resolution was placed in front of the Board of Supervisors. So subsequently, I complained to Mr. Lazar that I want this proposal in front of the Board of Supervisors Land Use Committee, and he finally calendared in front of the committee. There was the original hearing in front of the committee was postponed for a month for a possible compromise to be made, and then it was scheduled the last time for September 21st, 2009. And at that meeting, my brother and I were present at that meeting, and we were told that the item was put to the call of the chair, which, as you all know, means that it's continued indefinitely. So because the Art Commission, not the Art Commission, but Mr. Lazar and Mr. Kinsell had requested that the item be continued to the call of the chair based on this proposal that was made by the Hayes Valley merchants, which I sent you a copy on page 34. There's a statement there of the announcement from the Hayes Valley merchants stating that they wanted to offer that this subsequent proposal be put into effect. Well, since that time till now, which is something like almost another year and a half, I have not heard anything about it. So I asked Mr. Lazar the 2 questions in my complaint. Has the Arts Commission, I said, has anything developed in regards to this proposal that was presented to the Arts Commission as a compromise proposal, or has the Arts Commission and the Hayes Street merchants done anything to implement this proposal, since it was used to basically table our proposal in front of the supervisors? I did not even receive anything from Ms. Lazar, no letter, no letter asking anything, and basically it's a yes or no answer again, because I want to know if anything's been done, because if nothing's been done, I want to go back in front of the Land Use Committee and try and get this matter put back on committee there. And it's, like I said, it's taken me 5.5 years to this point here that I've been waiting, and all this requires is a yes or no answer from Mr. Lazar when anything's developed. And once again, he's not here today to answer your this question. If he was, I would ask for an oral answer to that question. And I would like to find out whether or not anything has been done, anything's been received, so that I can, if something has, I'll go in that direction. If something happens, I want to proceed to the Board of Supervisors. Thank you. I hope that explains it.
Is there anybody in the audience to present facts and evidence in support of the complainant? Seeing none, is a representative for the respondent present? Thank you for coming. You have 5 minutes.
Thank you. I'm Julio Matos, representing the San Francisco Arts Commission and Street Artist Program, Director Howard Lazar. As their representative, I was asked to deliver to you the following information relating to this complaint. In their complaint of June 14, 2011, the clerks state that it has been more than 10 days since I sent Mr. Lazar the email, and as of today, I have not received any response or information from Mr. Lazar regarding this public information request. In response, we state that the clerks are correct due to an oversight. The Arts Commission did not respond to the request. Our records show that we had received the clerk's email request on May 27th and that we had drafted a reply, but the reply failed to be sent. We apologize for this error and wish to take this opportunity now to convey our response to the clerk's questions. The clerk's asked, has anything developed from the proposal Director of Cultural Affairs, Louise Consell, and Mr. Lazar received in 2009 from Hayes Street Merchants President Russell Pritchard to commence a partnership between the Arts Commission Street Artist Program and the Hayes Valley Merchants Association to connect artists within the Street Artist Program with Hayes Valley Merchants to develop and institute a program of matching up artists and merchants, which will provide another avenue for local artists to show and to sell their work. We hereby respond that we have no documents or records of the occurrence of any development stemming from the proposal received from the Hayes Street Merchants President Russell Pritchard. Program Director Lazar had reported on receiving the proposal at the Street Artists Committee meeting of September 9, 2009, but since that time we have received no communication from the Hayes Street Merchants on their proposal. The clerks further asked, has the Arts Commission and or the Hayes Street Merchants done anything to implement the Hayes Street Merchants alternative proposal to our proposal, which was to designate 4 street artist sales spaces on Hayes Street? We hereby respond that the Arts Commission has not implemented the Hayes Street Merchants proposal.
Is there anyone in the audience to present facts and evidence in support of the respondent? Seeing none, the matter is with the task force. Member Nee?
Mr. Matos, please.
Yes, sir.
One basic question. Why has it taken so long to, 3 months, almost 3 months, to give 2 yes or no answers?
I have no comment on that one. At this moment in time, I have no comment.
So you have you don't have an answer to that question?
No, I don't.
Okay. Why is who would be able to answer that question?
Mr. Lazar.
And why is he not here?
I have no answer for that
Thank
one
you.
either.
Is there any additional comments or questions from the task force? Seeing none, the respondent and then the complainant will each have 3 minutes to clarify or respond. Do you have any? Let the record reflect that respondent has nothing further to add. The complainant will have 3 minutes.
I would just like to say that last month he was here prepared with that same document to respond. I sat here all night long to have an opportunity to speak. And if he was here last month, why couldn't they just send me an email and say that this was the answer to my questions? I mean, I'm really, I appreciate him being here doing his job, which I paid for him to be here. I mean, that's part of my thing. But I really feel that this all they had to do is send me an email saying this was the answers, and we wouldn't be here today. I would have withdrawn this from you, and I really feel that I think I sent to you a thing in the email there where Mr. Lazar stated he was very honored because he met with the China ministry with 27 representatives from the China ministry to answer all their questions in regards to the street artist program and all that. And yet he can't send me an email or answer these questions to me. And I just think that if that was the answer, Mr. Lazar knew this was going to be heard early. He could have been here, or he should have just sent me an email. And I think that whatever it is, I accept those answers as a response to the questions that I asked. And I would just ask you to send a letter to him or find him in violation of the 10 days or whatever it is, because this will, I'm just stunned that they couldn't have sent me an email. So I just ask for whatever it is that you can do to help make sure this doesn't happen to me again. Thank you.
Thank you. The matter's back with the task force. Member Washburn.
Yes, that's the big question here. What can we do to help ensure this type of thing doesn't happen again? So I'm going to ask other members of the task force to refresh my memory about what is it that we've done before. We have a repeat offender here, and this is beyond the pale. What can we do? Members.
This is in a different, this is a different case, but on page 60 of our packet is section 6253 of the California Public Records Act. And it discusses that each agency, upon a request for a copy of record, shall within 10 days from receipt of the request determine whether the request in whole or part seeks copies of disclosable public records. And if you go over to page 61 in bold, section D, nothing in this chapter shall be construed to permit an agency to delay or obstruct the inspection or copying of public records. It's not necessarily a public record, a written record, but the idea that you would use I don't understand why there wasn't a response at least between last month and this month, if they knew that was there. So it seems like an intentional delay. Member Costin?
And through their own testimony, it sounds like it had become a written record. The email purportedly was drafted and just not properly sent. So.
Is there a motion?
Well, I'll start one. I move to find violation of section 67.21B about time to respond to a request for a public record. 67.22 release of oral public information. This did not happen. We also have good old 61.21E, failure to send someone who can reply to our questions. And given, I'm tempted to find willful violations for every single one of these.
I agree. Through the chair. Should be
Did you finish your
67.34.
motion?
Yes.
So it's 6721B,
B.
6721E,
67.22.
22, and you want 6734, willful violation?
Yes.
And then was that a second, Member Costa?
That was a second. Yeah.
Member Nee?
I would suggest a friendly amendment. Instead of 67.22, I would suggest 67.22B, as in boy.
Hmm.
Does this-
67.22 has been satisfied, all right? The oral public information has been given tonight. However,
Not timely.
not timely.
Does
So
this-
I'd say 67.22B.
Does the second accept the?
Yes.
from The maker? So we're changing 6722 to. One question I would have would be, is it a motion to refer the willful violation to ethics or to do something with it as opposed to just finding it and issuing an order?
No, I think we should send it directly to ethics. Given
Does the
second
given
accept?
the history.
Does the maker accept?
Is there any? I just have is there any? Is there any issue with our bylaws regarding that? Don't our bylaws specify that we send it to compliance and amendments first, or am I remembering that wrong?
Well, it doesn't make sense to send it to compliance because there's nothing to comply with.
Well, I mean, yeah.
I mean,
but
there's.
that doesn't stop us from doing it.
He didn't say that. I don't have, I usually have our bylaws sitting right here. Can you? I was looking it up to double check. But I don't think the bylaws should limit us, DCA 3.
Through the chair, I'm looking at the bylaws. I don't see anything specific that requires that there be a referral to any committee. It does specify what the purpose of each committee is, but those statements don't require a referral. I believe that's at the call of the chair. Also, if I may, I often suggest that the task force make findings of fact to support its orders, and I think it's particularly important where there's a referral to the Ethics Commission for willful failure.
To clarify that, DCA 3, you mean state them so that they're clear?
For example, if the basis for the willful failure to comply with these particular sunshine provisions was the delay of 30 days between the last meeting and this meeting, that should be stated. If there's another basis for it, that should be stated in the motion.
Member Washburn?
Well, I think
Yeah,
there's
that's
the
it.
delay of 30 days. There's also the pattern here of the respondent who I'm speaking about, Mr. Lazar, who has been the subject of any number of complaints where we've found him to be in willful violation. He does not come to our meetings. And I think that's clear evidence that there's no intention to comply with the ordinance or to work with us, and most definitely to work with the complainants.
Member Costa?
I certainly agree. I think that it's definitely important to emphasize this particular sort of 1 month delay, particularly since it seems like this information was available and could have just, as Mr. Clark pointed out, could have been sent to him before the last meeting, but certainly in the time that has passed since the last meeting and this meeting. That's, in this particular instance, it seems to be the real backbone and pretty indisputably a willful violation.
So, Member Snyder.
I could take a crack at wording that as part of the motion, as a friendly amendment to your motion. Do you want me to try it?
Oh, sure.
Okay, so I would suggest...
Could you also, just briefly, just so that we don't have to go back, I don't know if it's, but like we have a 6721B for the time to respond, and I'm thinking that might be the initial, the facts of that is that they made their request. What was the initial day of the request? May 27th, 2011. So that would be the initial failure to respond. Is that what we're basing that on?
Well, I could say, so here's what I was going to suggest. See what you think. I would suggest putting the wording that I'm about to say at the outset of the motion. So the motion would be to find a violation of all the sections that you said, and then tack this on at the beginning. Based on respondent's 30-day delay in responding to complainant's valid request, semicolon, on respondent's repeated violation of the Sunshine Ordinance, and respondent's evident lack of intent to comply with the Sunshine Ordinance in the future, comma, the task force finds a violation, willful violation. I don't know if that captures everything, but maybe there's some...
In what I think is good advice from DCA 3 and having read the Ethics Commission's responses to us, they did, in the last 2 responses to us, they did say that they would send a letter to the people. So like 6721E, that violation is not based on the 30-day delay. It's based on the fact that they did not send a knowledgeable representative here tonight to explain to us why they didn't respond within the 30 days. So that's the, Mr. Matos, in his own admission, said he did not know and could not respond to that. So that's the basis for 6721E. Then 6721B could either be, because they didn't respond to the original request, which was May 27th, and then knowing that Mr. Matos had the document on July 26th, which was already late, they didn't respond within the 30 days between the continuance. So that's 2 findings of fact of 6721B. And then 6722B was that they didn't, it was oral information that could originally have been in the May 27th request that could have originally been provided orally, and it was not timely, it was not done so in a timely fashion based on, as Member Nee suggested, 6722B. Then Member Snyder's statement goes to 6734 because of the other 3. Because it was more than 30 days, 6721B.
Well, the other factor is that this is a pattern.
And a
This is-
pattern.
Yeah, that's, well,
Because you did say pattern in there.
Yeah. So how about this? How about what I'm trying to do in the precursor statement is hit each of the important factual points for each of the violations. So maybe try this. Based on respondent's failure to send representative capable of answering questions, semicolon, on the 30-day, and we could change that day number, but how about just on the protracted delay in responding to complainant's valid requests, semicolon, and on respondent's repeated violations of the Sunshine Ordinance and respondent's evident lack of intent to comply with the Sunshine Ordinance in the future, then the violations in series. The idea being that each of the kind of clauses set off by semicolons addresses the section violations in order, so that we could write it in some way that says, that breaks it up by section violation.
It kind of depends on how you, your preference. At my job, I end up writing a lot of demurs. So
Yeah.
your statement, I would say, here's the four things, and break them down so that each one is provided with our reasoning. But that, I think it's a matter of style, because I think we're saying the same thing. Member Washburn.
I think the point we need to be making is based on these, the pattern, the protracted length of time, we find willful violation of these, and then list that's the point we're trying to make, because we're going to send this to ethics. So we have to explain in our order of determination, the evidence that you cite in the initial clauses. Based on this evidence, we find willful violation, list all of the provisions that he's in violation of, and then that forms the basis for a referral to ethics. So I like that as maker of the motion.
So, which one is that? Saying
what I just said. Using Member Snyder's language to set out the facts and evidence clearly, the protracted length of time needed to respond. You had 3 reasons. We find willful violation, list the specific provisions, and then therefore we recommend that this matter be referred to the Ethics Commission.
Is maker of the second accept that form?
So should we restate that so that it's all, so that you have it, Chris? I mean, do you want us to restate it in whole so that you have it all?
That would be better. Through the chair, that would be much better, I think.
A shot.
Yeah, and we can listen back to this again ourselves too when we review the draft of the order.
Yeah, that's true.
So you can do that, and we'll all 3 double check.
So based on respondents,
Mr. Rustum?
Member Snyder, through the chair, I have it on tape, and all I have to do is transcribe it from there. Save time.
And I'll find where it is, and
I can forward it to you for your approval.
Okay. Is there public comment? Is there any additional task force discussion? Okay. Is there public comment on the motion?
Hi. Yes, Chairwoman, former chairman. I just want to stand in support of this, and I just want to remind you of a couple of things. Remember, last month, Mr. Lazar was here, and he walked out of this meeting with the Director of Programs, Jill Mantan, in the middle of the previous hearing. Mr. Lazar could have walked in the hallway and told my brother and I the answers to these questions, and we wouldn't be here wasting your time, wasting all these poor people's time that have to wait for us, so I'm going to try to be fast. But, I think that's an extreme example of willfulness on the part of Mr. Lazar. He deliberately refused to give us that information last month when he walked out of this hearing. And I think that the task force ought to mention that to the Ethics Commission in your letter to them. I respectfully, I don't believe a word Mr. Lazar says. He hasn't presented any evidence that they did write an email to my brother and I, and that for some reason it didn't get through to us. I don't believe Mr. Lazar. I believe that he didn't send it to us because Mr. Lazar has lied to us in the past. Now, that's my own personal position. So, I just want you to understand that not only was Mr. Lazar here last week, because you mentioned he has never been here. He has been here. He was here a previous time, just a month earlier, and he walked out on this task force right in the middle of the hearing so that you can't ask him any questions. And I just want to emphasize, I'm sorry, But I find it outrageous for him to be honored to discuss with the country of China, the 27 delegates of the country of China representing the 15 provinces of China, ask any questions about the street arts program, about the lottery, and about the art commission, and he refuses to come to this task force and answer any questions that this task force has. I think this is an outrageous conduct by Mr. Lazar, and I think that the time has come for this task force to, in uncertain words, pass it on to the Ethics Commission, how he's totally disregarding what the voters of this city passed and what we as the people demand of our city officials to be honored to answer your questions and to answer our questions.
Thank you. Is there further public comment on the motion? Seeing none, the matter is back with the task force. Member Nee.
Just as a point of information and without trying to deny what Mr. Clark has just told us, first of all, I was not here last month, so I don't know if Mr. Lazar showed up last month or not. I do recall that he and I believe it was Ms. Manton did show up 2 months ago, and as a hearing involving a case in which they were respondents began, they got up and walked out. We subsequently received a letter from Mr. Lazar apologizing for his having walked out and informing us that he had to do so because he was having an asthma attack.
That was the previous.
I believe that was our June meeting.
They did walk out last time too, and there was some public comment made about it.
Well, I believe it would be Mr. Lazar and Mr. Matos then who got up and left us at the June meeting.
Oh, okay.
That's my recollection.
Is there any additional discussion on the motion? Mr. Rustin, will you please call the roll?
Yes, Madam Chair. Member Snyder?
Yes.
Snyder, aye. Member Nee?
Aye.
Nee, aye. Member Washburn?
Aye.
Washburn, aye. Member Costa?
Aye.
Costa, aye. Member West?
Aye.
West, aye. Member Johnson?
Aye.
Johnson, aye. Madam Chair, we have 6 ayes. The motion passes.
Thank you. Thank you to the complainant and the respondent for being here. Mr. Rustin, will you please call the next item, which I believe is item 8?
Yes, Madam Chair. Item number 8 is determination of jurisdiction on complaint filed by Cynthia Carter against the San Francisco Municipal Transportation Agency for allegedly denying her access to her personal file.
Move to find jurisdiction.
Second it.
Is there any discussion on jurisdiction? Is there any public comment on the jurisdiction issue? Seeing none, public comment is closed. Mr. Rustin, will you please call the roll?
On jurisdiction, Member Snyder?
Yes.
Snyder, aye. Member Nee?
Aye.
Nee, aye. Member Washburn?
Aye.
Washburn, aye. Member Costa?
Aye.
Costa, aye. Member West?
Aye.
West, aye. Member Johnson?
Aye.
Johnson, aye. Madam Chair, we have 6 ayes. The motion passes.
Thank you. Will you please call item 9?
Item 9 is hearing on complaint filed by Cynthia Carter against the San Francisco Municipal Transportation Agency for allegedly denying her access to her personal file.
At this time, the complainant and the respondent will each have 5 minutes, beginning with the complainant.
There is no respondent here. Good evening. The person that they sent is not the person who I've been dealing with. They sent a Kathy Fallis. Caroline Salaya should be here. I'm opening this for the first time. This is what they've sent me. This is not my complete records.
Did you just receive this? Is that what you said?
I received this 2 weeks ago.
Okay.
This is a partial record. My files, I guarantee, are thicker than this. I asked for paperwork from supervisors, write-ups, numerous things, and I have nothing but my file. We have performance plans, appraisals, requests of leaves. I don't need that. It says employment, Discipline, this is not even complete. You know, suspension, this stuff is not complete. If I would have had all the records I needed that I requested, then I wouldn't have lost my civil service hearing July 18th, a paper that I needed to prove that a supervisor was harassing me, and that was one of the reasons why I was wrongfully terminated from Muni. I emailed back and forth with Caroline Salaya. I've sent 3-4 letters. She keeps requesting that I sign another paper. I told her I'm not signing anything. You need to send me my records. You know, I've sent you 3-4 letters. Where are they? Where are my records? All of them. Everything I requested, where are they? She's not here to answer the question. They sent somebody else again, like they did the last time we were here. They sent Cynthia Hamada, who could not, she had no involvement. Now they're sending Kathy Fallis. I mean, she can't answer the questions. I've dealt with Caroline Salaya. Why do they keep beating around the bush, sending other people instead of sending the person who I actually dealt with? Caroline Salaya. Muni is playing games like they always do, passing the buck to somebody, I don't know why. They do it, they get away with it, just like they got away with wrongfully terminating me. I want all the records pertaining to me. Thank you.
Thank you. Is there anybody in the audience to present facts and evidence in support of the complainant? You have 3 minutes.
Evening, the Sunshine Task Force. My name is Dorian Maxwell. The SFMTA does do a horse and pony show, as you've seen earlier today. They play games, they hide records, they only submit what they feel is necessary to comply with the Sunshine Task Force request, thinking that that is going to make things go away. But the thing of the matter is, we ask, in our request, we ask for all the documents that's in our files, hitting or our files that's at the divisions, the files that's within the Human Resources Department, the Labor Relations Department. We ask for all those things. And once you leave, all those files should go to one location, and all the information that's in those files should be available to us as an employee. We're not asking for someone else's personnel records. We're asking for our own, to look at our own records under 6254C of the California. We're not asking for somebody else's. We're asking for, she's asking to look at her own file. She's asking for all the data that's been collected against her over the years of her employment with the SFMTA to be provided for her. She's trying to she's trying to put together her lawsuit, and those documents that they're withholding may help her or may not help her in her case. And that needs, I feel that she needs to have access to everything that's in her file. Thank you.
Thank you. Is there anyone else here to present facts and evidence in support of the complainant? Seeing none, is the respondent present? Thank you for coming. You have 5 minutes.
Good evening, Honorable Chairwoman Johnson and Task Force
If you could
members.
speak into the microphone for the record. Thank you.
My name is Kathy Fowlis, and I'm here on the behalf of SFMTA. I'm the person, the custodian of records for the official personnel file section of Human Resources. We have complied with Ms. Carter's request. As you see, she did produce the documents that shows we did comply with what we had in her personnel file, which is her official one at Human Resources Division. As to the other documents, I cannot state or answer as to what additional documents Ms. Carter is seeking. I can only speak as to the personnel file aspect. So we have complied with Ms. Carter's request, and we do have documentation showing that. I can just present that, please.
Do you have any additional remarks at this time for your 5 minutes?
No, we just wanted to make sure that we are only here to actually address the agenda that is here, which is just with Ms. Carter's personnel file. And again, just to state that we have complied.
Thank you. Is there anybody present to present facts and evidence in support of respondent? Seeing none, the matter is with the task force. Member Nee.
Ms. Carter, please approach the microphone. Of the documents that you requested, which ones have not been provided?
Write-ups from supervisors. I do not have complete central control records. I do not have reports from the buses that I was driving, mechanical reports. And these files are not complete. These are not all, as far as, this is not a complete, like they told you, they have what they had. I'm sure somebody went into my files, took out what they wanted, that they didn't want to be shown, and disposed of them. I don't know who might have done it. They gave me what they wanted me to have. I don't have everything.
What don't you have that they should have?
Let me tell you what I did. I called Street Ops and talked to assistant manager. His name is Stewart. I asked him for my records for that, my write-ups from, the supervisors that the Street Ops supervisors had done. He said, I can't give those to you. I said, well, I have a right to them. He said, well, no, only an attorney can get them. I said, well, they're pertaining to me. Why can't I get them?
Okay, but what else? Write-ups from supervisors. From what you have requested from MTA, what is not there that you have
Those
requested?
are the three things I haven't received.
Okay, write-ups from supervisors and
Mechanical reports from defective buses. Okay, that was the three things.
Central control
and
records.
the central control reports, complete central control reports.
If I may, just to piggyback on that, the write-ups from supervisors, do you know they exist because you participated in them? Did you have to sign them?
Exactly.
Or could
I have write-ups from a supervisor that sexually harassed me, and when I went to civil service, I didn't have those records because they supplied me with this. This didn't help because I didn't have the write-up showing that he was still harassing me after I filed a sexual harassment complaint against him.
But you knew the write-up existed because you were present when it was written?
No,
or
because they tried to suspend me behind that write-up.
And they spoke of it? Or I'm just
Yes.
trying to
Yes.
place how you know the write-ups exist.
Oh, yes. I know. Yeah, it exists. That's how, because you receive mail. You receive mail, which is a discipline, the way they do it to discipline you, saying, we're going to suspend you for this amount of days because you did this. Which was, I was constantly harassed, retaliated against, but I don't have the write-ups from the supervisor. I asked for side letters from the for anybody, managers, superintendents, upper management. I didn't receive that.
Madam Chair.
Okay. Yeah, Member Nee.
Yeah, you've heard the respondents tell us that whatever you requested that they've given to you. Did and then you're telling us that there are things that you requested that you didn't get. When you got the material that you've just opened now, did you open it, or is this the first time you've opened it?
No, I knew what they were sending me. I went down
Okay.
there.
When you looked in that packet and saw things that were not there, did you go back to them and say, I don't have this, this, and this. I don't have write-ups from supervisors. I don't have mechanical reports on defective buses. I don't have complete central control reports. Can you tell me where I can go to get them? Did you ask them that?
I went down to 1 South Van Ness, sat down with a Christina, went through my files, and told her everything is not in here. This is not my complete file. You don't have everything I need. I said, where are the write-ups? Where are the supervisor write-ups? She said, this is all we have here.
Did she tell you? Did she?
I asked her.
Did she indicate that there were other places you could go to get those things?
No, she doesn't.
Did-
She didn't know
did
that. I
you-
asked her to get, where was Caroline Salaya? And she said that she wasn't there. I said, well, where's her supervisor? And she said she didn't know.
But did you ask if there were, the person you were dealing with, did you ask that person if there were other places you could go to get the information that you didn't have, that you had not received?
Yes,
Okay. And what was the response?
they didn't know.
Okay.
Member Costa?
When did you originally receive the packet of information that they sent to you?
Just 2 weeks ago.
And that was the first package of information you received in response to your request?
Yes.
Or had you received anything before that?
No, this is the only thing I received.
Thanks.
I have a question for Ms. Felice. There are two, these are not from you, they're from Caroline Salaya, but I'm wondering if you know, there were two extensions of time, 14-day extensions that were requested. One of them was requested 10 days after she made her document request, but they both waited a full 10 days before asking for another 14 days. And I'm just wondering if you could offer some insight as to why that amount of time was needed each time.
I think that package you have, I think that was the one with the agenda on it. I think that's the only copy that I had. We don't have that copy. I don't have a copy of that.
The one that you gave us? Or, well, there was Ms. Salaya, for example, on, I don't know if we have a copy that we could show her, but Ms. Salaya, there was a records request made on May 13th, and on May 23rd, Ms. Salaya sends a letter to complainants saying we need another 14 days. And I'm just trying to ascertain, and then that happened again on the other side of that document. The complainant requested documents on May 19th, and then on May 31st, she received a letter saying we need another 14 days. So that at that time they waited even longer than 10 days. So I'm trying to figure out the reasoning behind why they needed the extension of time.
I do not know. I cannot answer for Ms. Salaya.
And that would
I have
be
no
something
knowledge
that,
as to why she sent these letters to Ms. Carter, and I wish I could answer, but I cannot.
could you offer, as the custodian of records for the personnel files, could you offer us an estimate of the average amount of time it takes when people request their personnel file to send it to them?
It actually depends on how thick the file is, and it would depend on what documents the employee may be seeking. If the employee is seeking all of the documents, it can take us 1 week's time to get the documents prepared. We usually request that the employee comes and pick up their documents in person. And the reason we do that is because there is confidential information, such as their residence address, their social security, that we do not want to get lost in the mail. But if an employee does request that we actually mail out the records to them, we will, as a courtesy, we'll go ahead and do that, and we'll make sure that those records are sent out via certified.
Okay. And then I know that you said that you were here to address the personnel documents.
Correct.
So you're representing that your department does not keep central control logs or the
Correct.
mechanic logs, or the other thing would be write-ups from supervisors. That's not
Yes,
part of the...
that is not part of the official personnel file.
So
if the divisions
Was-
actually, I'm sorry.
I was just wondering if you received, since the complainant, Ms. Carter, had sent the request to the public records person, does that mean that the request was divided up among
Correct.
different people?
Yes.
So somebody else may have received the request for the central logs. Do you have any idea where those are kept? Do you
No.
personally know that? Okay, thank you.
So just to clarify, any records that Ms. Carter may have sought, if it was not given to Human Resources to actually place in Ms. Carter's official personnel file, we do not have knowledge as to where the documents would have been left or what division would be retaining the documents.
Thank you. Through the chair, Mr. Rustum, was there any, through the chair, I am the chair. Through me.
Glad I'm not the
Was
only one.
there- Was there, it's still, remember me. Did Ms. Celaya send us any reasoning why she did not attend, and did you send the notice to her?
She was notified of the meeting, but I did not receive any response from her.
Okay. Member Costa.
I just wanted to clarify. So Ms. Celaya is the custodian of public records for all of SFMTA. Is that right? Or the one who would be receiving the sunshine request and sort of delegating?
Correct.
Okay, thank you.
Ms. Fallis?
Yes.
Just have a couple of questions. So the write-ups from supervisors, are those something that would be in the personnel file?
It actually would depend on what type of write-up it is. If it's just a verbal meeting between an employee and their manager, it does not have to go into the official personnel file. It does not have to be forwarded to HR.
So the complainant requested write-ups, and she specifically referred in her testimony to a write-up regarding, I believe it was a sexual harassment complaint that she had filed. Why wouldn't that be in the personnel file?
Because that would fall under the EEO division. So if Ms. Carter did make a complaint with sexual harassment, discrimination, that would fall under that division. And those records, I believe, would be confidential, and therefore EEO would have to answer to those questions.
The complainant also referred to reports regarding defective buses that she had driven. Why would those not be in the personnel file?
I would believe those would be retained most likely with central control or the maintenance log. That would not be, again, a document that would be actually forwarded to HR.
Did anyone explain the two things that you just explained to me to the complainant at any time, to say you should look for these documents here or you should look for the documents there? You should go to EEO for the write-up, and you should go to central control for the reports about machine problems?
I cannot answer as to who Ms. Carter sought information from, but for me personally, if I am unclear, I would always refer the employee back to their union for clarification, or their shop steward for clarification.
Ms. Carter, could I ask you a couple of questions? Did you ask someone at MTA specifically for the write-ups regarding the sexual harassment complaint?
Yes, the initial letter did go to Ms. Fallis, but she told me that I needed to get additional information. I needed to see Caroline Celaya. So from there on, I was dealing with Caroline Celaya, who has given me nothing.
So did you ask Caroline Celaya specifically for the reports from the sexual harassment complaint, or regarding the sexual harassment?
Yes, I asked her for everything, and
What did she
she basically told me that she didn't know. And I also sent a letter to them stating that if you don't know where to find it, I'll come and look. Okay, I will go to Street Ops and get my paperwork from Street Ops. I will go to Central Control and get my paperwork from Central Control. These places, I'm fired. I'm no longer, why haven't my records come together, and why aren't they just in one place? I'm not an employer there. I'm not an employee there anymore. They fired me August 11th last year.
Did you ask EEO for any of for the write-ups regarding the?
No, you know what? I didn't even know I could go to EEO to get them.
So nobody explained to you that that's where they would be?
No.
What about for the reports? Did anyone ever say that you should go to Central Control?
No, I just knew to ask.
And what did?
I asked for the records, and I specifically called up to Central Control to try to speak to the manager up there. They did not. They refused to let me speak with them. I haven't called EEO. I did call Street Ops, where I can get the supervisor's reports. And again, like I told you earlier, the assistant manager told me that he couldn't give them to me because only an attorney can get them.
And which documents was that for?
The write-ups from the supervisor where I was sexually harassed.
Oh, I see. So for the report, you said you called Central Control to ask for those reports. And what was their response when you called there?
They didn't put the manager on the phone. I wanted to speak to the manager because I figured.
Did you tell somebody that you wanted, the documents that you were looking for?
Oh yes, I asked them how. I need to speak to a manager. I need to find out how I can get Central Control reports, recordings, and video cam. I wanted to find out how I can do that. They wouldn't put the manager on the phone.
And did you ask Caroline Celaya specifically for those reports as
yes.
well? Yes. And
it's in writing.
The request for those reports to Caroline Celaya is in writing?
Yes. To this day, I have spoken to Kim Fallis more than I've spoken to Caroline Celaya, which is never. We've emailed. I've called her office and never get an answer. I talked to Ms. Fallis more than I've talked to her, and Ms. Fallis has given me, I guess, all that she can. So now my problem lies with Caroline Celaya, or EEO, or Street Ops, Central Control.
Ms. Fallis, could I ask you another question? Is there any reason that you know of that Ms. Carter would not be able to have the reports about the are they called machine reports? The reports about the problems with the defective buses. What are those reports called?
Mechanical.
Mechanical. Sorry. Can't read my own writing. The mechanical reports. Is there any reason that you know of that she wouldn't be able to get those? That she would.
Yeah, since I'm not an expert with how the mechanical reports actually work or how they're logged or how long they're retained, I really feel uncomfortable trying to answer that. I'm not sure. I am really, truly not sure as to if those are still accessible at this time.
Okay, thank you.
Mm-hmm.
Member Costa?
Ms. Fallis.
Sure.
So you were the recipient of the original
Correct.
request on May 19th?
Yes.
So why was the personnel file not turned over, if I'm reading this right, till June 23rd?
When we receive a sunshine ordinance request from Ms. Celaya, what we do is anything that's based on that sunshine ordinance request is then returned back to Ms. Celaya. So personal records was made on the behalf of Ms. Carter, but because we received it through a sunshine ordinance, we will return all of the documents including our request, back to Ms. Zelaya. I guess she would then compile it all with what other additional documents Ms. Carter may have been seeking, or any other employee at that time. And at that one particular time, I guess they would present it to the employee or however they distribute it. But again, because I'm not Ms. Zelaya, I don't really know. I'm just assuming this is how it's done. I would assume you would compile everything that's requested within the letter, I guess, and present it to the employee at one time. That's what I would assume, but I could be wrong.
Thank you.
What, if, that's your the second, not the original one. That's fine. Ms. Fallis, in Ms. Carter's May 19th handwritten request to you, she does ask for central control logs. I'm curious, did you just relay to, how did you handle that part of the request? Did you tell Ms. Zelaya you didn't have them? Or?
As soon as we get the request, as soon as Ms. Carter forwarded me her request, that is automatically forwarded to Ms. Zelaya because it is a Sunshine Ordinance request.
Okay, thank you.
Yes.
Is there any further discussion on the task force? Okay, so at this time, the respondent and then the complainant will have 3 minutes to clarify or respond to anything. So we'll start with the respondent. If you could just sit down while she has an opportunity.
I'm through. Nothing else.
Nothing further?
No.
Okay. The complainant will have 3 minutes to clarify or respond.
Again, as I stated earlier, Caroline Zelaya needs to be here. Kathy Fallis has done what she was supposed to do. Caroline Zelaya needs to be here to answer these questions. Why don't I have all my records? You know, like I said, as a result, I lost my civil service case. You know, so this, pardon my expression, sucker got away with sexual harassment. Okay, he got away with sexual harassment. I need these records because I'm not stopping. I'm not stopping. Thank you.
Thank you. The matter is back with the task force. Member Neem.
Ms. Fallis? Just one quick question. Why is Ms. Zelaya not here tonight? She is the respondent in this matter. Why is she not here?
Based on the agenda that I received, it only related to the personnel file. That is my division, and therefore, I will be the one to come.
Thank you.
Mm-hmm.
I have some, let me address the DCA 3. The agenda item reads the personnel file, but the request was clearly for much more than that. Is there responsibility based on the agenda item, or is it based on the request?
Well, the agenda item gives notice to the public, but the complaint is against Ms. Zelaya and is broader than that. Based upon the complaint, Ms. Zelaya is the respondent. And, it could be Ms. Zelaya believed based on the agenda item that this was the appropriate person with the most knowledge. I don't know what her position would be, but she's not here to tell us.
Thank you. Just so the other members are aware, I have a real problem with the idea of allowing to slip by this idea that the respondent could wait the full 10 days and then request a 14-day extension. And as Ms. Fallis pointed out, one of the longest times to get a personnel file is a week. So, I mean, that's, I think it borders on purposeful delay, which when someone's employment is at stake is really a big deal. So I wouldn't want to set a precedent to just not say anything about that. Member Snyder?
I think that's within the requirements of the Public Records Act, though. I mean, they went up to the edge, but I think they actually, I mean, that's within their, they can ask for a 14-day extension.
But what about the 6253D? Nothing in this chapter shall be construed to permit an agency to delay or obstruct the inspection or copying of public records.
Well, I mean, but you have to read that in conjunction with the amount of time that the Public Records Act permits an agency to seek an extension. I agree that it's, you know, it's not the best
let
practice.
me just ask you this. In 6253C, it says that each agency, that they're, upon a request for record, shall, within 10 days from receipt of the request, determine whether the request or in whole or in part seeks copies of disclosable public records. Now, what it says about the 14-day extension is, in unusual circumstances, the time limit prescribed in this section may be extended. And that's what it says about 14 days. Do you think this is an unusual circumstance?
Well, I mean, I think that I guess reasonable minds could differ on that. Given that they did respond with something, I'm not sure that it was what they. I'm not sure that it's the entirety of what they should have responded with. But given that they did ultimately respond, they're playing fast and they're playing right up to the edge of the rules. But I think they're within them. I think a reasonable mind could probably decide that the circumstances weren't unusual. But she did say in her letter, she did give a reason for the delay or for seeking the extension, and. Whether we find that reason to be valid or not, I guess is for us to debate. I think it probably is. I think they're probably within their rights on the delay, but that's my opinion.
Madam Chair?
Member name?
I'm just wondering if 6253 wouldn't be trumped by 67.21B. 6253, the CPRA sets the floor for openness and compliance, but local ordinances are allowed to make the requirements a bit tighter. 6721B says a custodian of a public record shall, as soon as possible and within 10 days following receipt of a request for information, a request for inspection or copy of a public record, comply with such request. Doesn't sound to me like compliance was met under 6721B.
Yeah, I agree with that, and I feel very concerned that some of our complaints are turning into legal manipulation of words when the purpose of the Sunshine Ordinance is to get your records. So the idea of pushing it to its very limit is not in accord with the purpose of the Sunshine Ordinance, to do things in open government. The concern here with these employment records is that they could miss a hearing, they could miss a deadline. I mean, if it was something that was potentially going on for longer, but I agree with your assessment of that this is broadening under the local ordinance. Member Snyder.
I think and I'd like some discussion on this if anyone has any thoughts, but I think a more serious problem is the failure to assist the requester. 6721C requires that an agency assist somebody requesting information to identify where to look for it if the agency has an idea of where that may be. And I understand that MTA is a large agency with a lot of different departments, and it's kind of a maze, but somebody who's in MTA ought to be able to help in MTA management ought to be able to help direct a requester of records to the right place. And from the testimony we heard it sounds like the mechanical reports are located in a place that Ms. Carter found on her own and sought, and from whom she sought records. But Ms. Carter also testified that no one in MTA sort of assisted her to get those records, and it's the duty of the custodian of records to provide some guidance and assistance where that guidance and assistance is reasonably available. And it appears to me that it would have been reasonably available here, would have been reasonable for the custodian of records to say, we don't have those in personnel, but we will help you get them, or we will ask if you can have them. There may be reasons to exclude or to find that they're exempt from disclosure, but we will help you try to get them from central control. You need to go to EEO to get the write-ups from your supervisor. And I didn't hear any evidence that Ms. Carter received that kind of guidance. I think it's commendable that MTA responded to some degree, but they didn't go as far as, to me, I don't think they went as far as the ordinance requires in helping her find documents that weren't in the immediate possession of personnel. And a related issue is withholding of documents. Actually, I'm going to reserve that. I need to look at something a little bit more carefully. So I am just proposing for discussion 6721C for failure to assist the requester in identifying the existence, form, and nature of any records.
DCA 3.
Through the chair, with regard to the question of the timing of the response in the Public Records Act versus the Sunshine Ordinance, I believe the provisions are relatively mirror one another. If you look at section 67.25B, it states that if the voluminous nature of the information requested, its location or remote storage facility, or need to consult with other interested departments warrants an extension, it justifies an extension of 10 days and refers to the Public Records Act's provision where there's a 14-day extension. And the reason for the difference in days is, I believe, at the time the Sunshine Ordinance was passed, the corresponding government code provision provided for 10 business days. It has subsequently, as my understanding, been amended to say 14 calendar days. So it's still the same. It's 14 calendar days.
Member Costa?
And just while we're on the question of timeliness, it's, unless I'm reading it wrong, sort of regardless of whether we're talking about California Public Records Act or Sunshine, it seems that by the time Ms. Carter actually received her file, it was June 23rd. And even with all of these extensions, if we're going to sort of accept them as legitimate, I think the latest date that she should have received them was June 14th. So I think the point is moot. It seems like it wasn't a timely response.
Under 6721B.
Right.
I agree.
On the question of assisting the requester of records, would we be talking about the MTA's central custodian, Ms. Zelaya? Is that what you had in mind, Member Snyder, through the chair?
She's the person that the complaint is directed at, right? Let me check that.
Well, she contacted Kathy Fowlis, but Caroline Zelaya has been the ultimate respondent. She's Ms. Carter? Did you receive the documents that you just opened here in front of us from directly from Human Resources or from Ms. Salaya? Who mailed them to you, or do you know?
I don't know if is Christine under.
Can you speak into the mic for the record? I'm sorry.
Yeah, I believe they came from HR.
Did you mail it directly to her or through Ms. Salaya?
I sent it directly out. I
Directly?
sent it directly out, yeah.
Okay, thank you.
Ms. Salaya appears to be the main. I mean, she represented. I remember her representing her position to us previously as the generally custodian of records for MTA, and she is the person that Ms. Carter sounds like Ms. Carter dealt with primarily. I guess she would be the focus of that violation.
I say that Ms. Fallis directed me to Caroline Salaya. She told me that I needed to get anything else from her.
Okay, thank you. You can be seated. Who is Ms. Salaya's direct supervisor?
Is it Mr. Hill?
Well, Mr. Hill was
No.
Is she an employee of the board? Because Roberta Boomer is signing on her behalf, and Roberta Boomer's the secretary to the board. Because one of the issues is going to be we need Ms. Salaya here, so definitely 6721E for failure to send a knowledgeable representative about the other documents. Oh, DCA 3.
Yes, through the chair. I just wanted to actually come back to the question that you asked me about whether it was appropriate. I can't remember the exact question, but it was about my response was about who the actual respondent was in this case. And when I'm looking at Ms. Carter's complaint, which is on page 62, she doesn't actually name an individual as a respondent. She names department, SFMTA, and the person contacted is Kathy Fallis. So, I just want to correct my response because my response was based on stating that Ms. Salaya was the respondent. That's not correct.
What day did she receive the records again? Remember, Costa, you were talking about this earlier.
The 23rd, it looks like. Or that was when she was allowed to review them for the first time.
May 23rd or June?
June 23rd.
Oh, I see. Right. So it should have been by June 6th. Was that?
14th.
Well, there are two.
The latest would have been June 14th.
Right.
Yeah. Okay.
It seems like because Ms. Salaya has been designated as it seems like Ms. Fallis has turned over what she has. Perhaps she could have assisted a little bit more with the information, but she did refer, Ms. Carter is stating that she was referred to Ms. Salaya for the remainder of those documents. So it may be that we have to begin there. Name her. Member Costa.
I agree. I also think, though, and I think that Ms. Fallis's intent seems benevolent, throughout and well-intentioned. But the sort of procedure that seems to be in place at the MTA of if a request comes in and a big batch of the files that are being requested are employee records and the request is coming into the HR department, it seems problematic to me that then that has to be sort of shuffled off to Ms. Celaya or whoever is managing all of the records and then turned back around to the HR department. Then, it's sort of asking for some sort of a less than timely response or less than ideally timely response. And so, I don't, there's probably nothing we can do about it, but it seems like it might be worth just sort of noting that could be something for the MTA to revisit how they're dealing with those requests.
Well, I'm going to make a motion. I'm going to move that we find Ms. Celaya in violation of 6721B for not timely turning over the documents because she had asked for the extension and they would have been due, at the very latest June 14th, and she wasn't allowed to review them until June 23rd, and then they were not mailed to her until June 29th, and even then it was not by Ms. Celaya. And then 6721C, because she did not help Ms. Carter determine where the control logs and the mechanical records and the write-ups from supervisors were, because Ms. Carter is representing she did not know about the EEO. And then 6721E for not sending a knowledgeable person about more than just the one records request.
Second.
Is there any discussion?
Do we feel like that we can vote on that without first adding Ms. Celaya to the complaint specifically?
I think in light of the fact that her complaint here names the San Francisco Municipal Transportation Agency, and that more than one person from that agency has represented that Ms. Celaya is the custodian of records, including both of the people here tonight, I think that it's justified. Mr. Member Nee?
Not sure it should be part of the motion. Maybe it should, but I would, in the order of determination we issue, and this can be part of the motion, it might not be necessary, but in the order of determination, we should direct that the MTA provide to Ms. Carter the write-ups from the supervisors, the mechanical reports on defective buses, and the complete central control reports relative to her case.
I think we should make that part of the motion so that it's clear in the order.
Excellent suggestion.
Okay.
Does the second accept? You made it, so that's your friendly amendment?
It's a friendly amendment.
As a maker, I accept. So the three documents that she had requested. Is there any further discussion? Seeing none, is there public comment on the motion?
Members of the task force, Ray Hartz, Director, San Francisco Open Government. I hope you notice I've refrained on commenting on a lot of things tonight, which I usually don't. In this particular one, though, I will, because I taught supervision and management for 3 years for the United States Navy, and then for the University of Hawaii for 14 years. All of the courses I taught were business, but primarily in hiring and things like performance appraisal and how to appropriately remove an employee. And the only legitimate reason for removing an employee is because he or she cannot do their job. And for the complainant in this case to go to a hearing and have only the documents, and not have even the documents relating to her performance to go back and refer to in advance, is a disadvantage. But not having the supervisor's supporting documentation is critical. I was sued twice personally for firing someone. They said wrongful termination, but I was able to walk in and produce all of the supporting documentation, which was dated noted and initialed by the employee, stating that I had discussed everything with him, that I had done it repeatedly, and at one point the judge just looked at him and he says, "What did you want him to do?" He told you over and over and over again and warned you several times. What was he supposed to do? She should have had access to those records because, very frankly, from my experience, I know that a lot of times the real make or break issue in these is not whether they have a performance appraisal or some other standard required document. It's whether they can support the items in there with some sort of a provable record. In other words, somebody can walk in and say, "You're a lousy task force member," but unless they can cite specific issues or specific cases and give the times and the dates and so forth, it's not evidence, it's just my statement of my opinion. And with her not getting those records in general, she was at a total disadvantage in her hearing, and certainly being unable to question the basis of all those documents was in question, since she did not have the reports that she needed, and in particular the supervisory documents would show her write-ups and say, okay, the reason we rated you as a poor employee was because this happened and this happened and this happened. Other than that, it's just now a matter of opinion. And unfortunately, I've seen many employers do that. They wait till your performance appraisal comes along. You think you're doing fine because nobody said a word, and all of a sudden you're being told you're a lousy employee. And you're going, where did this come from? It shows bad faith. It shows that my intention was not to help you be a better employee. My intention was to hide this all from you until it was too late for you to correct it and then make an official record that I could put in there that you had no way of dealing with.
Thank you. Is there additional public comment on the motion?
Yeah, it seems to me that that the case of Cynthia Carter is not an isolated incident at the Muni and MTA. We have the case of Dorian Maxwell, who also has been requesting documents. So this raises the issue of systemic action by the MTA management to obfuscate, to prevent the public and employees from getting documents which they're required to present. And I think that needs to be taken up by this task force, particularly because these people are being fired without being able to get the documents. Now, what does this mean for the city? One of the things it means for the city is that these employees then go to a lawyer and sue the city of San Francisco and are engaged in a long legal process, costing the city money to hire lawyers to fight these people. This is not an effective way of running a city. And frankly, I think the MTA management and the mayor of San Francisco should be responsible and accountable for this. The person that's been brought in as the new manager of the MTA has no experience in transportation. This is a problem. You have a manager of this agency who is supposed to be running one of the most important transportation agencies in San Francisco, has no management experience in transportation. It's not a good omen for the public and the employees of the Muni Transportation District. So I support action being taken, and I think that there needs to be an investigation of the systemic violation of the Sunshine Ordinance by the MTA and Muni management and why this is happening. Thank you.
Thank you. Is there additional public comment on the motion? Seeing none, public comment is closed. The matter's back with the task force. Mr. Rustin, will you, I'm sorry, Member Washburn.
In light of what the member of the public stated, I know this will come to the complaints and amendments, but I'm also wondering whether the EOT might get involved in looking at whether there's a real systemic problem here and see if we can't help MTA be better custodians of record and more responsive to Sunshine.
I'm sorry, the equal employment opportunity. You said EEOs.
Oh, no, I mean.
Oh, the education, outreach, and training.
Training.
Okay.
Right.
You would prefer that the order of determination, well, we have to send it to compliance partially because
sure.
of the
No,
document
I said
request.
in addition to, we need to get a status report at compliance, but then also.
Perhaps that's something that the Education Outreach and Training Chair might consider putting on the agenda, contacting the SFMTA. We did that when I was on there, asking if they would like to have the PowerPoint presentation, or if somebody wants to come in, maybe Ms. Celaya would come in. I don't know. It's just something you might consider.
It may not be a voluntary thing, but, put them on the agenda and have them show up. The OT has done that in the past. Yeah.
Is there additional discussion? Mr. Reston, will you please call a roll on the motion?
Yes, Madam Chair. On the motion, Member Snyder?
Yes.
Snyder, aye. Member Nee?
Aye.
Nee, aye. Member Washburn?
Aye.
Washburn, aye. Member Costa?
Aye.
Costa, aye. Member West?
Aye.
West, aye. Member Johnson?
Aye.
Johnson, aye. Madam Chair, we have 6 ayes. The motion passes.
And the matter is referred to the Compliance and Amendments Committee. Mr. Reston, will you please read the next item? I believe that's item 12.
Item number 12 is determination of jurisdiction on complaint filed by Ray Hart against Luis Herrera of the Public Library for allegedly failing to include his 150-word summaries in the body of the minutes.
Move to find jurisdiction.
Second.
Is there any discussion of jurisdiction? Is there any public comment on jurisdiction? Seeing none, public comment is closed. Mr. Reston, will you please call the roll on jurisdiction?
On jurisdiction, Member Snyder?
Yes.
Snyder, aye. Member Nee?
Aye.
Nee, aye. Member Washburn?
Aye.
Washburn, aye. Member Costa?
Aye.
Costa, aye. Member West?
Aye.
West, aye. Member Johnson?
Aye.
Johnson, aye. Madam Chair, we have 6 ayes. The motion passes.
Will you please call the next item?
Item number 13 is hearing on complaint filed by Ray Hart against Luis Herrera of the Public Library for allegedly failing to include his 150-word summaries in the body of the minutes.
Thank you. Thank you to respondents for returning, and the complainant will now have 5 minutes. After read. Oh, I turned mine off. Is this the first time it's been on for you? Hmm? With the laptop, probably. We've done that before. We'll do it.
Members of the task force, Ray Hartz, Director, San Francisco Open Government. I want to make sure we understand the difference. There was a complaint that is 10054, which was a complaint that is scheduled to go onto the agenda next month for reconsideration of one of the statements where it said that a previous determination had made a decision that we later, through a subsequent hearing, 8-0 voted no. Ms. Blackman is here representing the librarian, city librarian Dennis Herrera, and this is specifically a complaint against Dennis Herrera, the city librarian. The reason I say that is Ms. Blackman is an employee of the city and county of San Francisco. Her direct immediate supervisor is Mr. Herrera. It is Mr. Herrera's responsibility to ensure that Ms. Blackman performs her duties in accordance with the direction of the law, including whatever determinations are made by this task force. He failed to do that. Ms. Blackman subsequently, in this particular case, prepared 2 sets of minutes in which she, having been to the hearings, knew that your determination was that the 150-word statement should be in the body, and yet she prepared them in 2 additional sets of minutes in the old way, which is putting them as an addendum. And at the Library Commission meeting where those were approved, I got up during both items and I said to them specifically that that was the case, and Ms. Blackman did not contest it, and yet they went ahead and approved the minutes as they were written. Now, while Ms. Blackman does perform her primary job for the Library Commission, she works for Luis Herrera, the city librarian. It is not the Library Commission's job to ensure that the law is complied with. It is Mr. Herrera's to make sure that his employee, who he supervises, does so. There is nothing new in Ms. Blackman's response to this. I have to assume that she has discussed this with Mr. Herrera. There was a complaint against him. He is not here to represent himself, and I find it almost implausible to assume that they did not have a discussion as to what she was supposed to be presenting here. However, I would ask you to consider this additional point. Ms. Blackman is caught between the rock and the hard place. She's being told by this task force to put the 150-word statement in the body of the minutes. She goes back to whoever, and they tell her no, and it is not her making that decision. She does not have the authority to decide to disregard your rulings. She does not have the authority to do anything other than what she is told to do by either the Library Commission or Mr. Herrera. In the event that the Library Commission tells her to do something which is inappropriate, which disobeying the directive of this body is, then it is up to Mr. Herrera as her immediate supervisor to correct that matter. He failed to do so. He sat silently during the entire discussion during both agenda items where these minutes were approved. He said absolutely nothing, and so basically he simply allowed it to occur. That was his responsibility. He failed to live up to it. And there was an old expression we used to use in the Navy all the time: delegation is not abdication. Simply because you delegate a task to somebody does not mean you are no longer responsible for it. What you are responsible for is their performance. And if their performance falls below the expected level, then it is up to you to correct that. And that is where Mr. Herrera sits. It was Ms. Blackman's understanding, and she can contest if she wants to, that there was an 8-0 decision that in the minutes means in the minutes, that there was also discussion about sending a letter to the city attorney to ask him to quit advising people, to say putting them in the addendum was okay. And there has also been some discussion that we're going to schedule next month a rehearing on 10054 and the determination that was issued to get that corrected, to take out the statement of fact that there had been a previous decision saying that that was okay out of that determination. But this is a separate matter. 2 additional violations: willful, blatant, disregarding what you decided.
Thank you. Is there anyone here to present facts and evidence in support of the complainant? Seeing none, is the respondent present? Much. You have 5
Yes,
minutes.
Thank you. Good evening. Sue Blackman, Library Commission Secretary. I'd like to clarify one thing that Mr. Hart said. I do report directly to the Library Commission. I'm an at-will employee, as is Mr. Herrera. He reports directly to the Library Commission. Mr. Herrera is my day-to-day supervisor in the office, but regarding the minutes, that policy is set by the Library Commission. Luis Herrera really has nothing to do with the policy of how the minutes are prepared. Having said that, this item has been heard. There is a referral to the Ethics Commission. previous minutes has been heard and an order of determination issued. That is still being in the process of going to the Ethics Commission. Mr. Hartz has chosen to bring the matter back up again before that item has gone through the entire process. At this point, I see no reason to issue another order on the same issue that's already been addressed. We also have the Vice President of the Library Commission here who can answer any questions that you may have on the Commission statement, but we are following the advice of the City Attorney, and Mr. Hartz referred to the fact that you were going to write a letter to the City Attorney. They have never received any such direction or any such letter, and they are still continuing to advise us that we are properly doing the minutes with the 150-word statement in the minutes as an addendum and referred to in the body of the minutes. Thank you.
Thank you. Is there anybody here to present facts and evidence in support of respondent? Yes. You have 3 minutes.
Okay. Good evening. I made a few remarks earlier. I'm Lee Munson. I'm the Vice President of the San Francisco Public Library Commission. And we take seriously our responsibilities under the ethics laws, and we are familiar and have tried to comply with the Sunshine Ordinance Task Force. I think there's some confusion. If you look at the ordinances, the Sunshine Ordinance Task Force does not say about anything about the particular placement in the minutes of an addendum or some comment. It just says it has to be in the minutes somewhere. So what we've tried to do is make the entire public document the minutes. And we will probably put a statement the next time around that says comments by speakers before the commission. If they're, 150 words is quite a bit when you realize that these guys stand up and speak 3 minutes worth on every agenda item that we have except adjournment. So if we put all that at the front of the minutes, it gets very, very tedious to anybody trying to read the minutes. And lots of times they take pot shots at topics that really are not relevant to the problem of managing a library. I won't quote some of the mantras an anonymous citizen mentions every time at each meeting, but the first line is stop the hate, stop the ignorance, don't give any money to the Friends and Foundation, don't accept any money from the Friends and Foundation. And he repeats that in front of every comment that he makes on each agenda item. I don't see how that's particularly helpful to put all that up in the very front part of the minutes. So what we will say, I think, is that I have something written out here, which I want to be sure I read it to you correctly. Comments provided by speakers are included in the minutes by reference and are available in the addendum at the end of the minutes. But we see the addendum as part of the minutes, and this is legal language. Included in the minutes by reference is an understood legal tactic for putting information farther back when it's more detailed, more lengthy, than it would otherwise make people. It prevents you from cluttering up the front of the report or a minutes or a presentation with a lot of stuff that is subsidiary to the main business of the meeting. And so that would comply, I think, with your requirements. It's in the minutes, and the charter, the section of the charter that deals with the Sunshine Ordinance Task Force does not say there's any particular place in the minute where comments from the floor have to be.
Your 3 minutes are up. If you could wrap up.
Yes.
Okay.
So we'd like to work things out with you and make sure that we comply with your requests, and we understand you've got a tough job. People will come before you and hammer on the table and say they didn't do it the way we want them to do it. Well, that may be true, but if we are on solid charter territory, and we get some help from the city attorney's office in that respect, we think that is a fair way to proceed, and it enables us to inform everybody. It's a public record. It's not something buried somewhere. It's a public record we're talking about, and this makes these documents, these statements from speakers, part of the public record of the minutes.
Thank you.
Thank you.
Is there anyone else here to present facts and evidence in support of the respondent? Seeing none, the matter is with the task force. Could I clarify one thing, Mr. Hartz? Are you bringing this complaint because they approved the minutes that were referenced in 10054, or is this a whole different set of minutes?
This is a whole different set of minutes. 10054 is settled as far as I'm concerned, and they disregarded that and went on with this complaint, took 2 more additional sets of minutes and just did it again.
Okay, thank you. Member Costa?
With regard to the clarity of the Sunshine Ordinance on the location of 150-word statements or public comment in general in the minutes, the location is in the minutes. And while the respondent argues that an addendum is part of the minutes, an addendum is not part of the minutes. An addendum is an attachment to whatever document it is an addendum to. And while I certainly sympathize with the frequency with which public comments are not germane to the topic being discussed, that's really not the place of that can't dictate their inclusion in the minutes. It is the public right to comment as part of the deliberation, and the minutes are to reflect what deliberations were. And so it has been the opinion of the task force that public comments are to be included in the body of the minutes. That's my personal take on this.
I just wanted to clarify, there is a letter that will be sent to the city attorney's office, because legally the best way to solve this is to use the plain meaning of the language in the minutes. There has not been, as far as I can tell, a specific ruling based on that. In addition, there's just one thing that concerns me is that, part of the reason we want to put them in the minutes is that it's not at the pleasure of any commission or board to abridge public comment they don't want to hear. And I feel that Mr. Munson really demonstrated that that's part of their consideration in the decision making, because he made reference that one of the members of the public takes pot shots, which sounds like something that they don't want to have, they'd rather not have in their minutes, which is a violation of 6715D. It's a way of abridging that comment. Now, it is, if it is in there attached to the minutes, in order to reconcile the confusion in the minutes, it's much more straightforward and not to have this conflict going on. In addition, I listened to the hearing that we had at Education Outreach and Training Committee, and I really want to point out that the Good Government Guide is just legal advice, and that is not the law. And if somebody were to take a matter like this to court, you could not cite that. Yes, your attorney gave you that advice, but that's not a legal. It may be a conflict that's going on here. I can see that, but it's not. That Good Government Guide also says that it's not an official part of the minutes, which there's no reference. There's nothing in anything in the Sunshine Ordinance that says it's not an official part of the minutes. I have no idea where that came from. So one of my concerns is that at Education Outreach and Training, Chair Costa specifically asked Ms. Blackman, knowing that the task force is interpreting this to mean in the minutes, as a part of the minutes, how will you proceed? And she says, we're going straight with the city attorney's recommendation to continue attaching them to the minutes. Those are just some of my thoughts. Is there any comment?
I mean, I completely agree. That's of great concern to me as well, and I think that is the problem that we ultimately need to rectify. And I think I will just reiterate Chair Johnson's reminder that ultimately the source of authority on this is the ordinance itself and not the Good Government Guide.
Is there any member need?
Just a couple of things. First, a technical correction of something the gentleman said, referring to the ordinance as part of the city charter, which it is not. It is part of the administrative code. And the reason I bring that up is that there have been differences of opinion that have come before this task force as to whether the ordinance and the administrative code carry equal legal weight with the city charter. So bear in mind that I would recommend that you bear that in mind as you move forward with this and any subsequent discussions. The other thing is that the gentleman mentioned that the minutes are supposed to reflect what happened at a meeting. And very often, something that a member of the public says can have a bearing on the decision that a body makes. It's happened a number of times with the task force here. Mr. Hartz and a number of people have brought forth during our meetings relevant points that have persuaded us in one direction or another. And so it seems to me that including what a public speaker says in the body of the minutes, it's a very important thing to do.
If there's no additional discussion, we will have 3 minutes from the respondent and 3 minutes from the complainant to clarify or respond.
Thank you. I would like to respond that the city attorney has issued not order, but a memo stating their opinion. They've issued an opinion on this, and we continue to follow that opinion. We believe, and the commission believes, that the addendum is in the minutes, and Mr. Hartz can say that it has to be in the body of the minutes. There is nowhere that it says that in the admin code. It says in the minutes, and the addendum is in the amendments. In any legal document, if you had an attachment and you reference that in the legal document, that attachment would be part of the legal record. And this is exactly what we're doing. We're mentioning it in the body of the minutes as an addendum, and therefore it is part of the public record. So that is our argument, and I don't know if you have any other questions, but that's kind of where we are. I will say that the Library Commission is going to discuss this as a separate item in one of the upcoming meetings to find out, to make sure the commission is clear on the direction that they want to go in. So that discussion will be happening.
Members of the task force, Ray Hartz, Director, San Francisco Open Government. First thing I'd like to do is point out the fact that what Ms. Blackman just said is incorrect. The city attorney has issued a memorandum, not a legal opinion. So we're talking what the law says versus a memorandum, which is really what the city attorney would like it to be. Secondly, you've heard from the vice chair of the Library Commission, and yes, his comments were, we don't like the comments these people make, and we don't want them in there. But the only way that those comments make sense is to read them in context. So somebody who is looking at the legal record, which is what this is, of the Library Commission meetings, would in many cases be totally unaware of how those attached comments, the 150-word summaries, relate to the actual item being discussed, because where the item is being discussed, Ms. Blackman puts in her description of what we said. And I think if you've read the documentation I provided in either of the cases, you will see what she puts in and what I write down are completely different things. And what she is doing, whether she likes to admit it or not, is she is abridging my right to free speech, because in each of these cases I very intentionally read the 150-word statement and then spent the remainder of my time expanding on it. So basically they can't say that, and final point is the Brown Act says that the whole idea of keeping people from having their say is to maintain the status quo. We like things the way they are, and these folks are coming here and they're trying to challenge what we're doing. And we don't want to be challenged. So we will do what we need to do, including, if you look at those minutes, put a big statement in bold black letters at the beginning of all the comments saying we take no responsibility, we don't account for their veracity. In other words, you can take these with a grain of salt, because we're telling you, as far as we're concerned, they're not up to snuff. So I think they even tried to pull that little thing. And as far as this being an additional complaint, it isn't like if you break the law once, you now get to break it forever again. What they did is they refused to put the comments in. They went ahead, and even though I got up in each of the instances and said, what you're doing is wrong, they went ahead and did it anyway. And I don't think you can get much more willful than that.
Thank you. The matter is back with the task force. Member Costa.
I move that we find a violation of 6715D for abridging public comments. 6716 for not including 150-word statement in the minutes, and also 6734 for a willful violation.
Second. Discussion. Member Snyder.
Give me 1 second. I need to look at something.
Okay. A friendly amendment to that would be to add to the motion that the comments be included in the minutes.
Accept. Yes, definitely.
I'm sorry, the summaries. Summaries be included in the minutes. In the body of the minutes.
So on on the 6715 abridgment, when we've dealt with that one in the past, it's typically been a situation where a member of the public body sort of stopped somebody from testifying or prevented or altered what they had said. And we didn't really hear, to my recollection, knowledge today, anything about that. I mean, is that based on the way they've summarized what he said, the 150 words? Because we didn't really hear much about that. I mean, the central issue today, it seemed to me, was the issue of whether this is going to be placed in the minutes. We didn't really talk about whether the 150 words in this case accurately summarized what, accurately summarized what Mr. Hart said.
Mm-hmm.
DCA 3?
Through the chair to Member Snyder, I believe in a previous complaint made by Mr. Hartz, he more fully laid out the case for that, and the task force found that there was a violation of that provision. So it may have been a meeting that you were unable to attend, but I think that was the case.
Yeah, I think that was the meeting. That was complaint 10054, and I think the meeting on that was January 25th. But I see in that order of determination, which I have in front of me, we did find a violation of 6715, but we didn't. In this meeting today, there was no testimony or any discussion about what the content of the 150-word summary was. So I'm just uncomfortable.
Are you talking about with the reference to Mr. Hartz's specific 150-word summary? Because when I had discussed 6715, it was because in the testimony, Mr. Munson had said, when he was explaining the reasoning why they don't include the summaries in the minutes, he had talked about there was one person that they had taken, sometimes they took pot shots, and there was one person who said the exact same thing every time. And so they were moving that out of the way. And that is it sounds like they don't like that.
Okay, so that's something separate. If we're saying that the 6715 violation is because this 150-word summary is not in the body of the minutes, that's one thing. But if we're saying the 150-word summary is a violation of 6715 because it doesn't fully and accurately summarize what the person said, in other words, it alters what they said, that it's based on the content of that 150-word summary, that's different.
Okay.
And I may remember incorrectly, but my memory, I was at the January 25th meeting.
You're remembering it correctly. He read something and it just said like the first sentence of a law.
Right. And so
you're correct.
The basis of our decision there was the content of the 150-word summary was the basis for the 6715 violation. And I would be in principle comfortable with that, but we didn't even talk about the content tonight. It wasn't really at issue, so I'm not comfortable with the 6715 violation tonight because we never talked about the content of the 150-word summary.
That would maintain some consistency.
I think my only, and I'm not going to stick on this, but I just want to offer this as sort of a slight pushback. The idea that perhaps, the mere act of if someone submits a 150 words summary of their comments, and it is in their right under the ordinance to have that included in the body of the minutes, and whoever's taking the minutes makes the decision to not include that and instead include their own summary, that seems like it might just inherently be an abridgment of the public comment.
You mean in place of?
Mm-hmm.
Their summary is in place of where the 150-word
summary
should be.
Mm-hmm.
Yeah. Well, so that's the first, that was the theory that Chair Johnson was talking about, the theory that it's a violation, it's an abridgment by virtue of its placement in the minutes.
I think that's sort of where I'm coming from.
So
for me, it's not.
That's
it's,
an
that's
idea,
not,
but
not,
I think that's stretching it too far.
Not because it's moved necessarily, but because that's what they said. They just got up here and told me that. They said that's the reason why they did it.
Okay, so we're deciding Mr. Hartz's case, and I can see Mr. Munson's discussion was about sort of general testimony that the Library Commission receives, and I can see how you can interpret it what he said as not as disfavoring certain types of remarks. But we're not hearing that case. We're hearing Mr. Hartz's case. And if we're going to decide that the movement, if we're going to decide that Mr. Hartz's 150-word summary was not placed in the body of the minutes because they wanted to abridge what Mr. Hartz was saying, okay, that's one thing, but we can't base our decision on that 6715 was violated because of abridgment, because of a sort of off-topic general comment that Mr. Munson made. I'm not comfortable. I'm also not comfortable with the idea that there's an abridgment within the meaning of 6715 merely by virtue of the placement of the 150-word summary. I can see saying there's an abridgment because the 150-word summary completely misrepresents what the testimony was, or it badly summarizes it, etc. But the mere placement in the minutes, to me, we have a violation that we've found that I feel is very solidly grounded. I think 6715 is less so.
Could I ask just one clarifying question? That when I seconded the motion of 6716, although we're finding just for Mr. Hartz, it would be kind of awkward if only Mr. Hartz's 150-word summary was the only summary that ended up in the body of the minutes. This is going to apply to all the 150-word summaries.
Well, we could specify. We could specify. I mean, so we're deciding this case, but we should say that it's we could say in the motion that it's
I just
the
want to
view
make
of the
sure.
task force that they should do this as a matter of practice.
Okay. I want to make sure that we were on the same.
I also have, just to make sure we're on the same page. So it's not, what I was saying is it's not the placement, but it's the replacement. It's not that they took his 150-word summary, which he submitted, and put it at the end. It's that they wrote in their own summary of that in the minutes.
Point of order. We take their statements from them. They write their statements. We do not rewrite their statements.
I know, but you place their statement in the addendum and then write another summary in the minutes.
Madam Chair,
Member Neem?
I move to separate out 6715D from the motion.
That's what you were just talking about. The motion has been made and seconded. Is there any discussion, including, do you want to remove your 6715D?
It was the separated out was seconded.
The motion was to separate it, meaning we
Right, and so we're
6715D separately from the other two or the other three components of the motion.
right, and so we're having a discussion of the separating them out. But I didn't know how wedded you were to having it in your.
Well,
Member West.
I can't speak for Member Nee, but I think the intent is we agree on the other aspects of it. We can get that out of the way and then move on to the discussion of.
Yeah, I think that's fine. Or just have or vote 2 votes.
Okay.
Yep.
Is there any public comment on the motion to separate the 2 motions? You're not a member of the public.
Can I just ask you to clarify the motion?
Yes, definitely. The motion is to separate out 6715D and make that a separate motion from the motion to find a violation of 6716 and have it a willful violation under 6734. And that also includes an order to put the summaries within the body of the minutes. Seeing no public comment on the motion.
Roll call on the separation
On the
motion.
separation and then the 2?
Roll call on the separation.
Can you call the roll on the separation of the motion for 67, separate 6715D from the motion.
On the motion, Member Snyder?
Aye.
Snyder, aye. Member Nee?
Aye.
Nee, aye. Member Washburn?
Aye.
Washburn, aye. Member Costa?
Aye.
Costa, aye. Member West?
Aye.
West, aye. Member Johnson?
Aye.
Johnson, aye. Madam Chair, we have 6 ayes. The motion passes.
So the two motions are now separated. So we will vote, is there any discussion on the original motion now with 6715D separated out? So that would be the motion to find a violation of 6716 and have it a willful violation under 6734 and have the order of determination order that the summaries be placed within the body of the minutes. Is there a discussion on that? Is there any public comment on that motion?
Audience gallery is empty.
Seeing none, Mr. Rustin, will you please call the roll?
On the motion, Member Snyder?
Yes.
Snyder, aye. Member Nee?
Aye.
Nee, aye. Member Washburn?
Aye.
Washburn, aye. Member Costa?
Aye.
Costa, aye. Member West?
Aye.
West, aye. Member Johnson?
Aye.
Johnson, aye. Madam Chair, we have 6 ayes. The motion passes.
And so that motion will end up being referred to the Compliance and Amendments Committee. And on the motion to find a violation of 6715D, is there any public comment? Seeing none, public comment is closed. Mr. Rustin, will you please call the roll?
On the motion, Member Snyder?
Yes.
Snyder, aye. Member Nee?
No.
Nee, no. Member Washburn?
No.
Washburn, no. Member Costa?
Yes.
Costa, aye. Member West?
Aye.
West, aye. Member Johnson?
Aye.
Johnson, aye. Madam Chair, we have 4 ayes and 2 noes.
Can we query Member Snyder on his vote? We're voting to find a violation of 6715D, and you had argued very adamantly against it. So I apologize.
I misheard the motion. Can I change my vote, please? I would like to vote
Is
no
that possible?
on that motion.
Do we have to resend the?
Sorry about
Yes. Well, I mean, he made such an adamant argument.
Yeah,
I was
yeah.
shocked.
Yeah, my bad. My brain is shut down.
So do we need to make a motion to rescind the vote? So I'm going to move that we rescind the vote.
Second.
Is there public comment on rescinding the vote? Seeing none, public comment is closed. Mr. Rustin, could you please call a roll on rescinding the vote?
On rescinding, Member Snyder?
This is on 6715D, that motion. Okay.
Yes.
Snyder, aye. Member Nee?
Aye.
Nee, aye. Member Washburn?
Aye.
Washburn, aye. Member Costa?
Aye.
Costa, aye. Member West?
Aye.
West, aye. Member Johnson?
Aye.
Johnson, aye. Madam Chair, we have 6 ayes. The motion passes.
So the previous vote on 6715D has been rescinded, and we will now revote on 6715D. And there is no members of the public present in the gallery, so there is no public comment. Mr. Rustin, can you call the roll?
On the motion, Member Snyder?
Yes. No. Playing with you that time. Everybody needs to relax.
Snyder, no. Member Nee?
No.
Nee, no. Member Washburn?
No.
Washburn, no. Member Costa?
Yes.
Costa, aye. Member West?
Aye.
West, aye. Member Johnson?
Aye.
Johnson, aye. Madam Chair, we have 3 ayes and 3 noes.
Motion fails.
Can I request a 5-minute recess?
What time are you leaving?
I can.
Okay. The chair declares a 5-minute recess. The task force meeting is back in order. Member Rustum, welcome to the commission. Mr. Rustum, will you please read the next item?
The next item, Madam Chair, is item number 14, determination of jurisdiction on complaint filed by Ray Hartz against Luis Herrera of the Public Library for allegedly failing to assist in identifying documents.
The mics aren't on. Could you repeat that?
I move to find jurisdiction.
Second.
Is there any discussion? Seeing no public in the audience, public comment is closed. What do you say I could say? Can you please call the roll?
On the motion, Member Snyder?
Yes.
Snyder, aye. Member Nee?
Aye.
Nee, aye. Member Washburn?
Aye.
Washburn, aye. Member Costa?
Aye.
Costa, aye. Member West?
Aye.
West, aye. Member Johnson?
Aye.
Johnson, aye. Madam Chair, we have 6 ayes. The motion passes.
Madam Chair, before we proceed with the substantive item, I think it's only fair to point out that our Deputy City Attorney, Jerry Threed, has left. And I think it's only fair to ask both sides if they want to have the item heard tonight without Mr. Threed present.
In light of that request, we will do so. Our Deputy City Attorney has left. We want to make sure that both parties are comfortable. We do have an attorney present. Member Snyder is an attorney.
Who specializes in sunshine law.
Yes. Mr. Hartz has a motion that he is fine with continuing, and the respondents have also now indicated that they are fine with continuing. Did we read the next item?
Item 15 is hearing on complaint filed by Ray Hartz against Luis Herrera of the Public Library for allegedly failing to assist in identifying documents.
Is the microphone on? Okay, you have 5 minutes.
Members of the task force, Ray Hartz, Director, San Francisco Open Government. You have a copy of this in your file. It is an immediate disclosure request which was given on July 21st to Luis Herrera. It is addressed to him, and the first paragraph is basically saying I'm asking for assistance in identifying documents, and 90% of the paragraph is a quote directly from the ordinance. The second paragraph was to give a general description of the type of document I was looking for. Pretty simple. On the Monday following the day I gave this to Mr. Herrera, I called Ms. Blackman at the Library Commission office, and I asked her, am I correct in assuming that Mr. Herrera has delegated this to you? She said yes. I said, is Mr. Herrera your direct supervisor? She said yes. I said, I'd like to ask how you plan on replying to this document when you have had no discussion with me whatsoever on helping me identify the documents. And her responses were just very vague. I told her several things. One, I told her that the request was for assistance in identifying documents, and it was directed to Luis Herrera, the city librarian. I told her that you have invoked the 14-day extension without any basis for determining the additional time to be justified. How can you say it's going to take, it's voluminous or take a long time, or you need to talk to somebody or whatever, if you have no idea what documents are being asked for in the first place? I also stated that basically that she was an intelligent person, and I didn't really think that her response was going to be a fair one for the simple fact that she didn't make any effort to discuss with me or help me identify the specific documents. So we didn't get an answer, and then I got a response that later that day invoking the 14-day extension and then also providing 4 documents. 2 of those documents were specifically documents I told her in our conversation I did not want, which was presentations by the San Francisco Public Library. I said I wanted audited figures and figures which the city librarian is required to provide either to the mayor's office, the comptroller's office, or budget and finance in his official capacity as librarian for the city and county of San Francisco. She sent me another document, which is a description on their procedure for asking for records. And then she sent me one which was not responsive to my request, but which I did manage to glean some information from. Reading it, it's called the framework, which is basically the arrangement between the library and the Friends. And in there, it specifies that they are required to do an annual audit. I was then able to do a separate IDR, which Ms. Blackman mentions in her notes, or in her response. I was able to ask for those 2 specific documents by quoting from the framework, and I had those documents by the end of the next business day. Now, what I will tell you that is different is that did not go through Ms. Blackman. It went through Mr. Herrera's executive assistant. So it seems when Ms. Blackman is out of the equation, things go much more smoothly. She then sent me a response a few days later, and basically we've identified 3 documents. She named them, and she said, we feel may be responsive to your request. So throughout this entire process, she made no effort to help me identify documents whatsoever. As I've said before, Mr. Herrera delegated this to her. She dropped the ball. That is his responsibility. The simple fact he gave it to her and she did not help me in any way is not workable. Bottom line is, Ms. Blackman seems to feel that when someone makes a public request for documents, she gets to just pick out random documents and send them to them. And that's not the way it worked. The way I described it to the library commissioner and to Mr. Herrera at the last meeting was if she worked at the information desk at the public library and you walked in and said, I'd like to get some information on German culture, she would go away into the stacks and come back with a Rick Steves DVD on travel through the Rhine Valley, a copy of Der Spiegel magazine in German, a German cookbook, and a copy of Mein Kampf by Adolf Hitler. And when you said, wait a minute, that's not responsive, she said, oh, yes it is, it's about German culture.
Is there anybody in the audience to present facts and evidence in support of the complainant? Seeing none, the respondent will have 5 minutes.
Thank you. Sue Blackman again, in my capacity as custodian of records this time. Mr. Hart's telling of the story is fairly accurate. He did send us or hand Mr. Herrera an IDR at the commission meeting. I did respond on the following Monday with 4 documents which I had easily accessible to me that I could provide to him immediately, that I hoped would at least get him started in the right direction. He wrote back that it was non-responsive, but then obviously he found something in one of the documents that I sent him that was very responsive to what he was looking for. He requested those specific documents, and they were given to him the following day. A few days later on the 4th, and I will say one of the reasons we asked for an extension is that several people were on vacation. The people that handle the Friends, a lot of our Friends' financial issues in the office were on vacation that week. I was then on vacation for a few days, but we did respond within the guidelines on every issue that he asked for help on, and we felt that we were very responsive. So I don't know what more we could have done in the period that was responsive within the guidelines of the ordinance.
Thank you. Is there anyone to present facts and evidence in support of the respondent? Seeing none. Oh, sorry. You have 3 minutes.
I don't think I'll need 3 minutes.
Okay. Could you speak into the microphone for the
Yes, of
record?
course. Sorry.
Thanks.
Ms. Blackman is is not just doing work for Mr. Hartz. The commission has things for her to do too, so she's got a very heavy workload. And Ms. Blackman also has to answer information requests for two other people who work closely, excuse me, with Mr. Hartz. They're the people I mentioned that every meeting they have 3 minutes of talk about each item on the agenda. And then between meetings, they each typically give her document requests, and sometimes they're immediate document requests. So this is not just she's got plenty of time to do this. She's got a busy day doing things for the commission, sometimes for Mr. Herrera, but we work her too, the commission. So his statement is just very, very general. She didn't do anything useful. That is belied by what she just told you. She gave him documents that he was able to use, go in and pick out things in those documents that he wanted, which she gave to him within 1 day or 2 days. That's a pretty decent performance, I'd say. Thank you.
Thank you. Is there anyone else present to present facts and evidence in support of respondent? Seeing none, the matter is with the task force. Is there any discussion? Seeing none, the respondent will have 3 minutes, and then the complainant will have 3 minutes.
I just wanted to point out that this complaint was filed prior to the time that we have given to respond. So he filed the complaint before we even had the time to fully respond to his request. So that in itself says that he was asking for these things strictly to set up a means to come to the task force to say that, in my opinion, to say that I was non-responsive. If he had given us the full time, we would have provided the additional information. And I will say that we did provide information on additional documents. He has not asked for any of those documents or asked for any other additional information since then.
The complainant will have 3 minutes.
I don't know how much more clearly I could have stated this case. My request was for assistance in identifying documents so that I could make a specific request for specific documents. It was not so Ms. Blackman could Easter egg the thing and just grab whatever documents she thought were appropriate and give them to it. That's one of the complaints that you hear over and over and over again, is that people's time is being taken up. Well, that's their fault. If they actually worked with me to help me identify the documents, in that one case I was able to, not because the document she gave me was responsive, but because it referenced a document that should exist, and I was able to use the language in it to say this document and ask for it. Not because I knew what it was called, but because it said in there that they were required to produce these reports. As far as being responsive, giving a response is not necessarily responsive. And in this case, what she failed to do is she failed to help me in any way to identify documents so I could limit the request. They complain, oh, we have so much work to do, and these are so voluminous and so exhausting. Well, if you actually sat down and had a conversation with a person and helped them and said, these are the documents we have, and the person said, I'll take that and that and that, as in the case of the second request, I was able to put the request in and got it immediately, and it was handled, sent it to me by email. It was electronic in format, so whoever the person was, Mr. Herrera's executive assistant, was able to answer that with a minimum of fuss. And that's what I'm talking about here. Mr. Herrera has set up a dynamic where if you really want public records from the public library, you have to go through this Durham and Strong and fight with them about it, and then they're going to send you whatever they want to send you and refuse to help you identify documents so that you know what is there and can make a specific request. That is unconscionable. And that is the basis of this entire complaint. And I don't have to wait until they finally give me response to file this, because once you figure out that somebody is not going to help you, it doesn't take a rocket scientist to figure out that you have a basis for at least a complaint on failure to assist. And that's the whole complaint here. Not what they did or didn't give me, but did they assist me in identifying documents which then would allow me to make a specific request, and they did not.
Thank you. The matter's back with the task force. I do have one. I did want to point out just one thing. It's not exactly related to the 6721C, but on page 144 of our packet, where the Library Commission is asking for, or is invoking an extension of 14 days in that second paragraph, it says your request is not simple, routine, or otherwise readily answerable and does not meet the criteria for immediate disclosure under the San Francisco Sunshine Ordinance. Accordingly, it is a standard public records request, not subject to the expedited time limit. That's a real misstatement there. That immediate disclosure requests are immediate disclosure requests, whether they are simple, routine, or otherwise readily answerable. The simple, routine, or otherwise readily answerable, if you read the 6725A, is your right to invoke the 14-day extension. So you cannot declare someone's immediate disclosure request not an immediate disclosure request and say that it's now under your jurisdiction to call it a standard request. But you are able to invoke an extension. It's just, if someone writes immediate disclosure request, it means that you know, if you're going to invoke the extension, you should do it by the end of the next business day, because it's difficult to leave that just sitting there because you can't declare it a standard public records request. But it doesn't mean you can't invoke the extension. So I just wanted to, sure, if it's directly to that, okay.
The city attorney directed me or advised me that that was not, that first language, I think I took it upon myself to say, well, he did it as an IDR, so I was going to consider it as an IDR. So I shouldn't have actually put that language in there. We did consider it as an IDR, and we did ask for a 14-day extension, and provided him with the information that we had at the time.
Okay, thank you. Yes, yes.
How can you invoke a request when you have no idea what the person's asking for? How can you say it's voluminous, stored somewhere else, you need to talk to somebody else, whatever, and that's the whole complaint. Is she made no effort to actually have a discussion with me to identify the documents. So if you don't know what the documents are, how can you tell whether the extension is appropriate?
Is there any further discussion of the task force? Is there a motion? The matter is concluded because there is no motion. Thank you for staying. Mr. Estem, could you read item 18? I'm hoping we could have a quorum at least for just that item.
Item 18 is issuing public reports evaluating compliance with the Sunshine Ordinance and related California laws by city departments and officials pursuant to Section 67.30C.
I asked for this to be placed on the agenda because we'd been having so many issues with specific departments. And I noticed that under that section, it says that we can issue public reports, kind of similar to how the grand jury issues public reports or the controller issues an audit. So I wondered if the task force members were interested in issuing public reports about the different, on compliance by the different departments based on what we've heard, since there are a lot of other things have not been successful. For example, the street artist program we hear a lot about, or the MTA, or if we're concerned that the Board of Supervisors is being disrespectful of public comment. Member Costa.
I am fully in support of this idea, particularly because I feel like a lot of the matters that come before us, on a lot of the matters that come before us, there ends up being a considerable amount of public opinion amongst the people in the room. However, I think that a lot of these issues, unfortunately, never really make it outside of the hearings. In terms of the more general members of the public being aware or becoming aware of the compliance or lack thereof by various city agencies with the Sunshine Ordinance. And I think that these would be a good way to kind of foster a broader awareness in the city of the people, the agencies that are complying and those that aren't, and just sort of the work that the task force is doing.
Member Nee?
Couple things. First of all, when we say issuing public reports, to whom would we issue them? I mean, would this just be us coming out with a report and then sending it out to the news media, or would we send it to the mayor and the Board of Supervisors and expect them to comment on it? Where is the report going to go if we come out with it?
My thoughts about it were that they would be posted similar to how the civil grand jury report is posted, issued to the media. I got a call, from the media about a couple of the cases that we heard, and I just thought that it was, a way of summarizing the kind of problems that we see here. And it could be posted on our website the same way that the controller's audits are posted or the civil grand jury report is posted.
And then also, what system or procedures would we use for compiling these reports? Would we develop a list of city departments and agencies and commissions that we want to scrutinize? And if so, how would we determine which ones? Once we determine which ones, how would we actually conduct those examinations or those scrutinies? Would we be having special meetings, calling witnesses? What's the process here?
I didn't intend it to be an investigation, but a summary of our hearings, our findings, all in one space. Member West?
So this would be kind of a backward look, in other words?
Yeah. One of the suggestions that I was going to make to the Nascent Technology Committee was essentially to I see an opportunity to essentially build a historical record by mining the minutes, as it were, in an automated way, i.e. writing a script to identify parties and the various things, and basically building a database. And then once that's been created for a historical record, a tally could essentially be kept much more easily going forward. Unfortunately, it's just an idea. I certainly don't necessarily have the time to implement it right now. But I think that so my goal with that idea would be to sort of grossly identify all orders of determination, what agencies, possibly persons that they were found against, so that at least there could be sort of some record, i.e., the SFMTA generates the most complaints. I'm not saying they do, but for example, it could turn out that the SFMTA was the largest generator of complaints, which I think is information the public might like to know, or that a particular agency has been found in willful violation the most time. The problem is that compiling that manually, as Member Nee pointed out, would be incredibly time intensive, especially if conducted sort of in open meeting, which is why I would essentially suggest sort of an automated means. And I think that working with Member Wolf and any other members who have yet to be identified of the Nascent Technology Committee, we could come to a solution with that through the meetings of the Technology Committee.
Member Costa.
I agree with Member West's suggestion. I think that would be a tremendously useful thing, and I think it's it's definitely within reach. And it would be great to have a robust database of everything that would be queryable and referenceable. But I think that also there's sort of a separate issue here of doing more sort of distilled summaries. I don't know. That's how I'm envisioning this. Like maybe on a. I mean, you could decide the frequency of them, on a quarterly basis or on a monthly basis. It seems like at almost all of our meetings there's at least one case where we say, wow, this is a repeat offender. We've heard the same case 6 times in the last 6 meetings. And it seems like that's the sort of thing that the public should know about, and it seems like they don't. And so whether it's by a vote at the end of a meeting, what the report's going to be, or just a sort of broad kind of compilation on a somewhat less frequent basis, I do think that this kind of conveyance would be a positive thing.
I mean, sorry.
That's all right.
Just to respond, I mean, my only reservation with an approach like that is my concern that anecdotal evidence, i.e., essentially could unduly so the reason I would go with an automated approach is because it would offer a relatively unbiased look at the data as opposed to sort of an anecdotal approach where for example, a particular member of the public could bring a number of complaints against one agency, and that might be more indicative of the bias of that member of the public and not necessarily the performance of that agency in relation to the Sunshine Ordinance. And it would turn up over the course of a quarter as anecdotal evidence of a repeat offender, but sort of over the course of a year or 2 years or 3 years, that might not necessarily be the case. So I think both approaches are entirely valuable. I just think that an approach that sort of that an ongoing approach would help to have a historical record of data to essentially provide a sanity check and normalization against sort of data going forward that anecdotally might appear convincing, but sort of compared against the historical record actually isn't. I may be going into way too much detail with this. So
I didn't necessarily have in mind that we would make these rulings or statements, but we have all these orders of determination.
Yeah.
And I like their idea too, but I've also liked it for a year and a half.
Right.
So I don't think that it's going to, I don't trust that it's going to happen in a timely manner. And I see people becoming interested in the task force. We were listed on there's a couple as a political wonk freak who can't get out of it. It's the mayor's thing. So I'm, I read some of the calendars to see if there's anything I want to go to. I don't go to as many things as I used to, but we've been started showing up on them, our meetings. And I think it's an opportunity to demonstrate that I don't think they necessarily have to be biased, but we have these orders of determination. For example, this thing about the minutes with the city attorney's office, or the issue of attorney-client privilege, just issues that we see coming up continually before us, like the street artist program, and not necessarily saying they did this and they did that, but we found this violation or that violation, just as a report. Member Washburn.
I'm thinking maybe, I like the idea of having this database that we could query and get very fine-grained data that would be informative. But I also see some urgency in perhaps, and one thing we could do would be to maybe look back over the orders of determination for the past, say, 3 years. Look at the types of violations we found. We could report out that, but then also look for sort of what we see as critical cases or the most egregious problems we found, like having this noise ordinance task force that violated every single. Yeah, there's some real key cases I think that I think the public ought to know about. Or the Laguna Honda gift fund, and how we've found, these black holes from which we could get no light. So I think things like that, or just this. It's not just Mr. Lazar. There are other people who don't come to our meetings. So I think we could report out some. We've seen a lot of these types of violations. And maybe this particular agency's been before us, these 3 agencies. But then I highlights carefully of several cases that, and the public would go, wow, that's interesting. I mean, I tell my friends and family about some of the cases, and they're like, wow, I think we could, the public needs to know, and I think it would also generate interest in Sunshine. So,
Member Costa.
Some ideas.
I completely agree with that, and I wonder what other members think about this, but I can sort of see, just as those sort of matters are being considered, just as we talk about, well, we should, send a letter about this to the mayor or to whomever, saying maybe we should, whatever we're going to do, whether it's going to be a press release or a report or whatever, we should also let the public know. We should make an announcement to the public that this has happened, because the public also deserves to know.
Mm-hmm. Yeah. I was going to suggest that about the noise ordinance task force as a case.
Well, the section says, it specifically says to evaluate compliance. Public reports evaluating compliance with the Sunshine Ordinance and related California laws by city departments and officials. I mean, that's literally what it says. So I like the idea of a database, but it's not that I don't think it's going to happen anytime quickly or soon, So I just wanted to get an idea. My initial thought was to look at the orders of determination and maybe do some sort of a tally of if there is, it stemmed mostly from the street artist program, hearing this over and over again and not having anything necessarily come from it. And then, I thought, well, how can we get this information out there so that other people are watching? I think sometimes only a few people complain because only a few people watch. Member Neem?
Yeah. When we look at orders of determination, we should also look at the follow-up on those. In other words, determine whether those orders of determination were met, determine how many cases we actually had to refer to ethics or one of the other enforcement entities. I think, just looking at orders of determination is fine, but we have to, we have to go beyond that.
Go beyond the.
Well,
The order of determination is still a violation. For them to have to come here, they're complying with the order, but they're not complying with the ordinance.
Well, in some cases, granted, ignorance of the law is no excuse, but in some cases, the violation was not willful.
Yeah.
But it's not about tattling. It's about monitoring their compliance with the ordinance. It's not about willful. It's that, if the MTA, for example, Member Washburn and I were like at odds, are they doing it on purpose? Which I tend to go through. She's like, how could they not have been trained? So it's not me, it's not like a report saying they're doing this on purpose. It's that here's what's happening at the MTA. So I don't know if that's exactly it, but perhaps I could do a tally and see how difficult it would be to include the follow-up in that too, the outcome. I mean, the Noise Ordinance Task Force is an easier one. Member Washburn.
I was wondering if it would be possible, this sounds like a project for some interns or an intern. Find some enterprising students who need course credit or need experience to work on this project.
To tally?
Mm-hmm. Well, to gather the orders of determination. Yeah, do the grunt work. I mean, we would have to evaluate all of this, but
I think interns is a great idea, but the reason I'd raised my hand originally is I have to go, so I apologize.
Do you have public comment on it? Could you stay for public comment and then we'll go?
Sure.
It's just one person, so that we can complete the item.
Members of the task force, Ray Hartz, Director, San Francisco Open Government. I like the idea, but I'm not sure what the objective is. If it's to put it out there so that we get a whole bunch of angry villagers at the gate with pitchforks and torches, I don't necessarily see that happening. So I would like to suggest an alternative. Pick specific issues. I think probably if I were going to guess, the most egregious issue you have is not sending a knowledgeable rep. And you probably have people who repeatedly send people who can't answer the questions you have, and as a result, hold up everybody in the process. And what I'm thinking is if you just go back and look at the decisions and say, okay, over the last 3 years, we've made this many determinations, and this many of them related to each of these specific departments, and pick the top 5 offenders and list them in order of frequency. And then send a letter to the department head saying, we're considering doing a report on the lack of response from some departments, and we wanted to get your input because you are one of the top 5 departments who fails to send a knowledgeable representative on a regular basis. I would guarantee you that at least some of those departments would start making damn sure that you had somebody here, because just the idea that you might file a report and might place it on your website would be enough to goad them. And the reason I say that as opposed to issuing the reports themselves is the fact that issuing the reports may just get you to turn them into a more stubborn creature to deal with. Someone who says, fine, if they're going to mess with me, then I'll just mess with them. I won't respond at all. But if you hand it internally and send them something which they can consider and go, oh, God, if they do this, you may find you get a response back saying, I wasn't aware that this was happening. Nobody told me, because unfortunately, a lot of times that stuff doesn't go to the boss. But I will ensure that my custodian of records knows that this is the requirement, and when there is a case, I will have someone from my department who knows what they're talking about show up. So really, I'd suggest look at what your objective is and what's the best way to get the objective. And I think picking particular issues that are problematic for you in conducting your business, and then looking at that and sending some very quiet letters to the department heads and getting their response might be more fruitful.
Thank you. Seeing no one else in the audience, public comment is closed. And without objection, if I consider continuing this to the next meeting, is there objection to that? Okay. Then we're losing quorum, so the meeting is adjourned.